May I be pardoned, my lord? Item number 64. Lord, item number 64 in your lordship's list.
Yes.
There is a IA for release of documents. The main appellant died, his wife has been widow has been substituted. The LIC policy bonds, for release of the LIC policy bonds, I have filed an IA. Let it be listed, taken up next week for orders, listed for orders.
Okay. All right.
My lord, item 34.
May I pardon to mention, Lord?
Yes.
Item 34, that our substantive period of 11 years. 11 years and the fine. Already he is also in custody more than 11 years and 8 months. And my lord also pleased to grant some interim bail, whereas he has been surrendered. Only my prayer, let this matter be taken up for orders, whereas it can be disposed of.
Yes.
34.
My lord, this appeal matter 3 assist, my lord.
Keep it.
IA for extension of interim bail, my lord. HIV patient, my lord. Health concern.
Orders.
10 years conviction, already 8 years passed in custody.
My lord, item 55 weekly.
Yes.
My lord, tired of bail matter.
Tired of bail matter, co-accused person has already been released on bail. This honorable court has called for the case status report, but till today not listed.
Keep it.
My lord, weekly item 45. We fix it.
Okay. Yes.
Pardon mention, my lord, for criminal leave petitions against order of acquittal in the section 130 NI Act case. My lord. The petitioner is old lady.
Keep it. Yes, sir.
I may be pardoned. Lordship, one BL appeal 5542 of 23, which I have already prior I have mentioned, in which I have filed an IA of 752 of 23.
All right. Noted down.
Lordship,
I may beg your pardon, your lordship. My lord.
Yes.
On the last week also, I mentioned this matter, your lordship. This is weekly list 53. And I have filed an IA for bail. May be taken up as orders, your lordship. Because out of...
All right.
My lord, subject to your lordship's kind acceptance, may I mention another matter?
Yes.
My lord, one IA I have filed 990 of 2023, in which the date of surrender is due for tomorrow, but due to some exigency, medical exigency, the petitioner could not surrender. I have filed an IA for extension of time. Can it be taken up?
Right. Give the number. It will come next week.
I have already. I'm obliged, ma'am.
Weekly list item 1.
My lord, item number 1 may kindly be taken up next week. Any date, my lord.
Give it. Yes. It's a pattern matter. You are wrong.
My lord, a senior is suffering from viral fever.
You are.
And tomorrow, my lord.
Sorry. Madam. Yes, read the FIR. Any note was there? What are the charges framed?
Charges framed, my lord, 498A and 304B and 34 IPC.
No for DP Act.
No, my lord, charges not for DP Act.
On the matter, so you call you the other person. Infinity is 498 by 34, then 304B by 34.
my lord.
Okay. There are 5 appellants here.
5 appellants, my lord.
5 accused persons. All of them have been found guilty.
My lord.
So Prahalad Behera,
Prahlad is the
Gopinanda
husband.
Behera, Draupadi Behera, Parameshwar Behera, deceased is Lakshmi Priya.
My lord.
Okay. Let us come to the judgment and see what are the offenses under which he has been found guilty. All the 5. So the operative part is at
Operative, my lord, page 40, internal page 25, that is the judgment part with regard to conviction, my lord.
wait.
RI for 2 years.
Just a minute. So it was held that prosecution failed to establish the charge under section 304B.
4B, my lord.
So he was, all the accused persons were found guilty under 498A
My lord.
and 306.
My lord.
Sentence is 2 years,
RI,
5,000
fine,
in default,
6 months. My lord.
pay a fine of in default 6 months. Okay. RI for 6 months.
My lord.
Then 306, it is 5 years.
5 years.
Fine is also 5,000.
My lord.
And in default, RI for 6
6
months.
Yes.
And then sentences are to run concurrently.
My lord.
Okay, now come to the FIR.
Lordship.
Yes, you place the FIR.
My lord, only the relevant part I will read in second paragraph.
Read the entire FIR.
My lord. ମୁଁ ଶ୍ରୀ ମାର୍କଣ୍ଡ ବେହେରା
Who is Markand Behera? PW?
PW 3, my lord.
Okay, yes.
ବୟସ 56 ବର୍ଷ, ପିତା ଗୋବିନ୍ଦ ବେହେରା, ସାଇ ସୋଆନସୋ ଡିଷ୍ଟ୍ରିକ୍ଟ ସୋଆନସୋ, ଆପଣଙ୍କ ସ୍ଥିତିରେ ହୋଇ ଉପସ୍ଥିତ ହୋଇ ଏହି ଲିଖିତ ଅଭିଯୋଗ ଜଣାଉଛି କି ମୋର ତୃତୀୟ କନ୍ୟା ଲକ୍ଷ୍ମୀପ୍ରିୟା ବେହେରା ବର୍ଷ 19 ବର୍ଷ
ବାରିପଦା ଟାଉନ 21 ନମ୍ବର ୱାର୍ଡର ନିବାସୀ ଶ୍ରୀ
ରାସବିହାରୀ ବେହେରାଙ୍କ ସାନ
ରାସବିହାରୀ ବେହେରା ସାନ ପୁଅ ପ୍ରହ୍ଲାଦ ବେହେରାଙ୍କ ସହିତ ଗତ 13/10/2000
Rasbihari Behra is an accused in this case.
My lord, he was an accused. No, my lord, he was not registered.
He
as
was
an
not an
accused.
accused.
My
Okay.
lord, not an
Rasbihari Behranko, yes, read out.
ରାସବିହାରୀ ବେହେରାଙ୍କ ସାନ ପୁଅ ପ୍ରହ୍ଲାଦ ବେହେରା ସହିତ ଗତ 13/10/2011
So, just a minute. Let us see the appeal memo. Prahlad, Govinda, Draupadi, Parameshwara, Kati, ठीक है. See serial on JH. So, that means appellant number 1 hela husband.
husband. My lord, 2 is the Dedasura, brother-in-law.
Just a minute. A2 Govinda hela Dedsura,
Dedasura, my lord.
elder brother-in-law.
Draupadi Behra,
Just a minute. Dedsura. Then 3 number A3 is Draupadi Behra.
my lord, she is the
Mother-in-law.
mother-in-law.
So A4 is
Or is
Parameshwar Behra,
uncle-in-law, my lord, Kaka Susura.
uncle-in-law. Then appellant number 5,
5 is the aunt-in-law,
Kati alias Bharati Behra.
my lord, Khudi Sasu.
Is the wife of
Wife of my lord, PW4.
Okay,
Sorry,
appellant number.
My lord.
I mean Khudi Sasu.
Khudi Sasu.
Okay, read out.
13/10/2019 ବାଲେଶ୍ୱର ଜିଲ୍ଲା କ୍ଷୀରଚୋରା ଗୋପୀନାଥ ମନ୍ଦିର ରେମୁଣା ଠାରେ ବିବାଦ ଦେଇଅଛୁ। ବରପକ୍ଷଙ୍କ ଦାବି ଅନୁଯାୟୀ ପ୍ରାୟ ଟଙ୍କା 70,000 ମୂଲ୍ୟ ଯୌତୁକ, ଝିଅର ଖୁଚୁରା ଉଚୁରା
Khuditasura.
ଖୁଡ଼ିତାସୁର ଓ ପରମେଶ୍ୱର ବେହେରାଙ୍କ ମଧ୍ୟସ୍ଥତାରେ ଦେଇଅଛୁ। ବିବାହ ପରେ ଅଧିକ ଯୌତୁକ ତଥା ସୁନା ହାର, ସୁନା ମୁଦି, ସୁନା ବଳା ଏବଂ
ଅଲଙ୍କ ଓ ଟେଲିଫୋନ
ନ ଆଣିବା କାରଣରୁ ଝିଅକୁ ତାହାର ମାମୁଁ ସୁନା ଦେଇ
ତାର ଶାଶୁ
ସୁନା ଦେଇ ଖୁଡ଼ିତାସୁର ପରମେଶ୍ୱର ବେହେରା, ଖୁଡ଼ିତା ଶାଶୁ ପଟି ବେହେରା, ଦେଢଶୁର ଗୋବିନ୍ଦ ବେହେରା ମାନେ ନାନା ପ୍ରକାର ମାନସିକ ଓ ଶାରୀରିକ ନିର୍ଯାତନା ଦେଇ ଆସୁଥିଲେ। ଗତ 21/4/2001 ଶୁକ୍ରବାର ସକାଳ 8ଟା ସମୟରେ ଝିଅ ଫୋନ କରି କହିଲା ଯେ ମୋର ଜୀବନ ବିପଦପୂର୍ଣ୍ଣ ଅବସ୍ଥାରେ ଅଛି, ମୋତେ ଶୀଘ୍ର ଏଠାରୁ ନେଇଯାଅ। ସଙ୍ଗେ ସଙ୍ଗେ ମୁଁ ମୋ 2 ପୁତ୍ରଙ୍କୁ ନକୁଳ ବେହେରା ଓ ଜ୍ୱାଇଁ ଘରକୁ ଆସି ଦେଖିଲା ଯେ ମୋର ଝିଅକୁ ମାଡ଼ ମାରି ହାତର ଜଙ୍ଘ
ଶଙ୍ଖା
ଭାଙ୍ଗି ମଥାର ସିନ୍ଦୁର ପୋଛି ଦିଆଯାଇଥିଲା। ଝିଅକୁ ଏହାର କାରଣ ପଚାରିବାରୁ ଜାଣିଲୁ ଯେ ଅଧିକ ଯୌତୁକ ନ ଆଣିବା କାରଣରୁ ମାମୁଁ, ଖୁଡ଼ିତା ଶାଶୁ, ସ୍ୱାମୀର ବଡ଼ ଭାଇ, ଖୁଡ଼ିତା ଶ୍ୱଶୁର ଏମାନେ ସମସ୍ତେ ମିଶି କାଣ୍ଡ ଘଟାଇଛନ୍ତି। ଆମ୍ଭେ ଝିଅର এই ଅବସ୍ଥା ଦେଖି ସାଙ୍ଗରେ ନେଇଯିବାକୁ ଚାହିଁବାରୁ ପରମେଶ୍ୱର ବେହେରା ଓ ଶ୍ରୀ ଗୋବିନ୍ଦ ବେହେରା ଆମକୁ ପ୍ରତିଶ୍ରୁତି ଦେଲେ ଯେ ଆସନ୍ତା ଶନିବାର 22/4/2001 ଝିଅକୁ ଛାଡ଼ି ଦେଇ ଆସିବୁ। ଆମେ ଦିନ ପ୍ରାୟ 1:30 ସମୟରେ ଘରକୁ ଫେରି ଆସିଲୁ। ମାତ୍ର ସେଦିନ ସନ୍ଧ୍ୟା ପ୍ରାୟ 7ଟା ମଧ୍ୟରେ ଏହି ଘଟଣା ଟେଲିଫୋନ ଯୋଗେ ଖବର ପାଇଲୁ ଯେ ଝିଅ ପୋଡ଼ି ହୋଇଅଛି।
So the date of occurrence is 21/4/2000. Yes, then what happens?
ସାଙ୍ଗେ ଆମେ 2 ଜଣ ବାରିପଦା ବଡ଼ ଡାକ୍ତରଖାନା ଯାଇ ଦେଖିଲୁ ଝିଅର ଗଭୀର ଶରୀରରେ ପ୍ରାୟ 60ରୁ 70 ଭାଗ ପୋଡ଼ି ଯାଇଛି। ଝିଅକୁ ଏହାର କାରଣ ପଚାରି ବୁଝିଲୁ ଯେ ତାର ଶାଶୁ ସୁନି ବେହେରା, ଶାଶୁ କଟି ବେହେରା, କକା ଶ୍ୱଶୁର ପରମେଶ୍ୱର ବେହେରା, ସ୍ୱାମୀ ପ୍ରହ୍ଲାଦ ବେହେରା, ଦେଢଶୁର ଗୋବିନ୍ଦ ବେହେରା ମାନେ ଏକତାବଦ୍ଧ ହୋଇ ଝିଅର ଉପରକୁ କିରୋସିନ ଛାଟି ଦିଆସିଲରେ ଜୀବନରୁ ଶେଷ କରିଦେବାରେ ଚକ୍ରାନ୍ତ କରୁଥିଲେ। ବାରିପଦା ବଡ଼ ଡାକ୍ତର ପରାମର୍ଶ ଅନୁଯାୟୀ ଝିଅର ଜୀବନ ବିପଦପୂର୍ଣ୍ଣ ଅବସ୍ଥାରେ ଥିବାରୁ ତାକୁ ବଞ୍ଚାଇବା ପାଇଁ ଆମ୍ବୁଲାନ୍ସ ଯୋଗେ ଟାଟା ବଡ଼ ଡାକ୍ତରଖାନା ନେଇ ଭର୍ତ୍ତି କଲୁ। ବର୍ତ୍ତମାନ ଝିଅ ମୃତ୍ୟୁ ସହିତ ସଂଗ୍ରାମ କରୁଅଛି। ଏ ପର୍ଯ୍ୟନ୍ତ ଝିଅର ଶ୍ୱଶୁର ଘରର ଲୋକ କେହି ଝିଅକୁ ଦେଖିବାକୁ ଆସିନାହାନ୍ତି। ଏହା ସୁପରିକଳ୍ପିତ ଯୌତୁକ ଜନିତ ହତ୍ୟା ଉଦ୍ୟମ ଏବଂ ମୋର କୌଣସି ସନ୍ଦେହ ନାହିଁ। ଆମେ ଆଜି ଟାଟା ଡାକ୍ତରଖାନାରୁ ଫେରି ଏଠି ଏତଲା ଦେଇଅଛୁ। ଏଣୁ ଆପଣମାନଙ୍କୁ ଅନୁରୋଧ ଏ ବିଷୟରେ ସତ୍ୟାସତ୍ୟ ଅନୁସନ୍ଧାନ କରି ଆସାମୀମାନଙ୍କ ପ୍ରତି କଠୋର କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗ୍ରହଣ କରିବେ।
So the FIR was lodged on 22/4/2000 and registered under section 498A 307/34 IPC, right?
4 DP Act was there.
4 DP Act 9?
Yes, my lord. Lords, you kindly see the endorsement, page 46. That was
In the top, in the formal affair, it is not there.
in the formal affair that is not there, but endorsement in the
Endorsement at page
46, Lords, you kindly see.
All right, 4 DP Act is also there. Okay. So when the deceased died,
26 April, my lord.
where she died?
In Tata Hospital, Tata Memorial Hospital.
So that means occurrence on 21/4/2000 and death took place on 26/4/2000. Any dying declaration?
Dying declaration is there, my lord.
Page number
7.
Is it oral or written dying declaration?
Written dying declaration.
Achha. Who is the witness?
Witness, my lord, lordship, the magistrate.
Dying declaration recorded by?
PW4.
Dying declaration recorded by?
By the executive magistrate.
No, PW.
PW4, lordship.
PW4 is the executive magistrate.
My lord.
In that Tata Memorial Hospital?
In Tata Memorial Hospital. Because after admission in district headquarters hospital, Keonjhar.
So let us come first to that dying declaration.
Lordship. Page 88.
Yes, you read it.
My lord, on 21/4/2000, I was working as executive magistrate cum Tahsildar Baripada. As for the direction of SDM Baripada, I had gone to record dying declaration of deceased Lakshmi Priya Behera, wife of Prahlad Behera of village Bhogudakota. I came to the hospital at about 10:30 to 11 p.m. IAC town PS has accompanied me. Police identified injured Lakshmi Priya to me. Lakshmi Priya had been admitted into female surgical ward. The entire body of Lakshmi Priya has been burnt. She was not in a condition to make any statement. In spite of that, I put her some questions.
Just a minute. Yes, she was not in a position to condition to make any such statement. Yes. Read out.
My lord,
in spite of that, I put some questions.
I put her some questions. She stated before me that she set her ablaze by pouring kerosene on her body. She further told that her mother-in-law and aunt-in-law abused her since morning, and at about 8 p.m. she burnt herself.
Just a minute. Okay, read out again once again that
My
paragraph
lord,
2. She stated
before me that she set her ablaze by pouring kerosene on her body. She further told that her mother-in-law and aunt-in-law abused her since morning, and at about 8 p.m. she burnt herself. She further told that her husband and father-in-law had not scolded her. She further told that her marriage had been performed about 7 months back and that she was carrying for 2 months pregnancy at that time. She further told that none had told her with regard to dowry articles except scolding her.
Okay. Continue paragraph 3.
My lord. Though I had put several other questions, but she did not give any answer, and she complained that since she was having severe burning sensation, she was not prepared to make any other statement. I recorded her statement by Exhibit 7. Exhibit 7 by 1 is my signature. Exhibit 7 by 2 is the signature of Lakshmi Priya Behera. Lakshmi Priya Behera was not in a normal state of mind at the time of making her statement.
Read the cross-examination.
My lord. Cross-examination. No medical officer was present at the time of recording declaration. Lakshmi Priya signed rising from the bed. I have not mentioned in my report that she did not like to make any other statement to my questions as she was having severe burn sensation. I have also not mentioned in my report that Lakshmi Priya was not in normal state of mind at the time of making statement. When I asked Lakshmi Priya about the reason for the females to abuse her, she did not disclose the reasons. It is not a fact that Lakshmi Priya was in a fit and proper state of mind to make such statement.
So from this statement, at least it appears that there was no doctor when the dying declaration was recorded. So whether the deceased was in a fit state of mind to make any dying declaration, that is absent in this, because the witness himself stated that he was not in a condition to make any statement. So once she has sustained extensive burn injuries on different parts of the body and was not in a condition to make statement, in spite of that you are recording statement, then at least the certificate of the doctor should be obtained that yes, we verified him and he is able to follow the question and answer it correctly.
To that extent, my submission is what I find, my lord, from the findings of the law and court below, my lord, the Exhibit 7, the dying declaration, that is being signed by the. I could not go through because that is not part
Okay, let
of
us
the.
see that. That is that.
She has given and a signature on that. My lord.
Exhibit 7 is the.
Yes, my lord. The dying declaration.
Dying declaration.
When she is giving signature.
Just a minute. ये exhibit list out. Exhibit 5. Six. This is 7 dying declaration. Okay. Have you got a copy of your dying declaration?
My lord.
Read out. It seems it was recorded on 21/4/2000 and time it is given at 10:30 p.m. Okay. This has been taken as per the order of the direction of subdivisional magistrate Baripada मोर नाम अच्छी पर आपण पाखे कहले dying declaration अच्छी थी सीटा.
My lord, it is not there, my lord. I'm
Okay.
sorry.
Have you got the copy?
That is
Acha.
not
It
on
reads
part.
like this.
My lord.
मोर नाम लक्ष्मी प्रिया बेहेरा. मो देहरे मु निजे किरोसिन ढाली पोड़ी होई अछि. मो upare sasu or khudita sasu. That means this appellant number 3 and appellant number 5. Both gali गुलज करी कहिले सकाळु ठारू गाली दउथिले. मु रात्र प्राय 8टा समय किरोसिन ढाली पोड़ी होईची. मोर स्वामी किंबा ससुर गाली देई नाहांती. मोर विभागर गत 7 मास होई अछि ओ 2 मास हेबो प्रेग्नेंट अछि. ଯୌତୁକ କିମ୍ବା ଅନ୍ୟ କଥା କିଛି କହି ନାହାନ୍ତି, କେବଳ ଗାଳି କରିଛନ୍ତି. So that is perhaps one of the reason why the London trial court has acquitted
from
the 304B.
That is.
And the doctor further stated that she did not state as to why this both appellant number 3 and appellant number 5 were abusing her since
that
morning.
The reason is omitted.
The
reason is omitted.
The reason is not there. So one, I find that the doctor's certificate not there about fit state of mind. And witness himself, that is PW4, himself says that she was not in a condition to make any statement. Implicated only
3 and 5.
A3, appellant number 3 and appellant number 5. Right? Then it is only abuse, not for dowry. Then reason for abusing not told by the deceased to PW4. Hello? She was pregnant for 2 months, okay? Now, this is dying declaration. Now we'll go to our family members' evidence.
Before going, Lordship, she has put her signature. That is the...
Okay, let us see that. Exhibit. The doctor stated that the victim, the deceased, put her signature.
That is the discussion.
Huh?
That is the discussion.
Let us say. I recorded her statement by Exhibit 7. Okay, 7/2 is the signature of Lakshmi Priya Behera. Okay, so signature is there. Okay, any other person, either the family member of the deceased or anybody else,
they
were
were
present
not there.
at the time of recording
No,
bank
they have
declaration?
denied, my lord, to have they are at the time of recording of the statement.
No,
PW
because
1,
the other exhibit 7 Bhargav. You see,
my lord.
exhibit 7 indicate
My lord.
that recorded in presence of parties, read over and explain and admitted the same to be correct. ତେଣୁ ଏଇଟା ଅନ୍ୟମାନଙ୍କ ପ୍ରେଜେନ୍ସରେ ହେଇଛି ବୋଲି ଏଇଟା ଲେଖା ହେଇଛି।
My lord.
ତେଣୁ ସେ ଅନ୍ୟମାନେ ଯୋଉ କହୁଛନ୍ତି who are they? Have they been examined during trial?
During, my lord, examination, they have denied.
Who are they? Who,
my
first
lord,
tell me who are those
PW
witnesses? PW2.
3, my lord.
So no one has stated that
He was present at the time of the recording of
he or
dying-
she was present at the time of recording of
dying.
dying declaration by PW4, right?
My lord.
Okay, now let us come to the evidence of the any father, mother, anything.
Father, my lord, PW3.
PW3, all right. So
the informant and
he is also the informant, right?
My lord.
Okay, you place the evidence of PW3.
My lord. I know the accused persons. This is Lakshmi Priya is my daughter. I had given her in marriage with accused Prahlad on 13/10/99. 5 to 6 days prior to the marriage, one Banko Behra village Komta gave the proposal for the marriage. Accused Parameswara and Govinda had come to my house to finalize the marriage proposal. They demanded cash of rupees 25,000 after accepting the proposal. I agreed finally to pay 11,000. They claimed to take the cash 3 days prior to the date of marriage. As regards other articles, I had told to give as per my capacity. Accused Govinda and Parameswara came to my house 3 days prior to the marriage to take 11,000. Nakula Behra, Danadar Putti, and Sudhanshu Giri were present when I handed over cash of rupees 11,000 to Sudhanshu Giri, who handed over the same to accused Parameswar. It was decided that the marriage would be performed in the temple of Lord Khirochora Gopinath Vijay at Remuna on 13/10/99. The marriage was held. Accused Parameswara and his brother invited us to attend the Chaturthi ceremony to be held on that night in their residence. Sudhanshu Giri, Danadar Putti, and my sons Radha Govinda and Lakshmi Narayana went to the house of the accused persons on that evening carrying utensils, TV, and clothes, etc. The articles were handed over to the accused Parameswar. My sons returned to our house on the same night, handing over the articles, and expressed before me that they were not given proper respect by the accused persons.
Yeah, just a minute. So date of marriage is 13/10/1999.
99.
Okay. So far as this demand of dowry is concerned, there was no charge under 4 DP Act.
No.
Because FIR was registered, but no charge.
No charge.
And deceased also stated for dowry there was nothing.
Nothing.
So now all this evidence regarding demand of that there was a demand and he was paid, that becomes now not material. Okay, now what has happened so far as we are focusing on 498 and 306. So what has she stated? Yes, read out.
My lord. Accused Sunni, mother-in-law of my daughter, and accused Kotti, wife of accused Parameswar, demanded other articles and expressed dissatisfaction for non-delivery of furniture, TV, antenna, gold ornaments like necklace, gold ring.
All right.
After 1 to 2 days, the marriage, my eldest son came to the house of the accused persons and took my daughter Lakshmi Priya to our house to observe Bahuda. Accused Prahlad had also accompanied my daughter. During time of Bahuda, accused Prahlad told Lakshmi Priya in my house to demand other articles from me. Rasibhari came to my house on the next day and took away his son and my daughter to their house. Thereafter, accused persons did not allow my daughter to come to my house. Accused Prahlad came thrice to my house with my daughter, and all those occasions accused Prahlad was persuading my daughter to demand the articles from me. 10 to 12 days prior to the death of Lakshmi Priya, I got a letter from my daughter through a female. Police seized that letter on my production white Caesar list marked Exhibit 1. Exhibit 1 by 1 is my signature thereon. Police also seized a school hand note book of the deceased along with the letter. After
That letter has been marked as an exhibit.
Exhibit, ma'am.
What is that exhibit?
That letter was written by the deceased to the father, my lord.
Yes. What is that exhibit?
Exhibit 1, my
Exhibit 1.
No, exhibit 1 is the seizure list, he said.
That letter, my lord, has not been missed.
Then?
That letter is not there. That only seizure list has been.
What is there in that letter? That is very much material. All right. Yes, after receipt of the letter?
My lord, after receipt of the letter, I went to the house of the accused persons.
Just a minute. So that means letter written by the deceased was seized
along with
under exhibit 1. Hello, right?
My lord.
But later not produced during trial.
My lord.
Any handwriting expert opinion also
No,
that is not there.
That has not been obtained.
No. Handwriting experts opinion about the author of the letter was proved. Okay, then what happened? After receipt of the paragraph 7, you read
Yes,
it. After receipt of the.
After receipt of the letter, I went to the house of the accused persons along with Sudhanshu and reached there at 8 p.m. When my daughter started crying, seeing us, accused Kotti and Sunni pushed her inside a room and closed the door. When Sudhanshu Giri inquired from Lakshmi Priya as to the reason for the dispute, she told that the accused persons were demanding gold ornaments and she was being ill-treated for non-giving of the same. Lakshmi Priya further complained that she was not being given food to eat and was being assaulted by the accused Sunni and Kotti. She further told that accused Prahlad was also assaulting her. Accused Govinda impressed upon me to settle the family matter and accordingly we returned to our house. On 24/2000 at about 8 a.m., my daughter made a telephone call to me. We came to the house of the accused persons at about 9 a.m. On that day, I found no vermilion mark on the forehead of my daughter, and bangles and shankha were also not in her hands. My daughter cried, holding my hands. Wife of the accused Govinda took Lakshmi Priya to the house. When I gave proposal to take away Lakshmi Priya to my house, accused Parmeswara and Govinda impressed upon me not to do that as it was their family affairs. At the time of our departure, when Lakshmi Priya wanted to see us, accused Kotti gave a push to Lakshmi Priya and put her inside the room, and accused Kotti at the time said that Kotha kahile saribo nahi. Accused Parameswar and Govinda gave assurance to me to bring Lakshmi Priya to my house with her husband on the next day after pacifying the situation. On that very night, that is 21/4/2000 at about 8 p.m., I got message over telephone that my daughter had sustained burn injuries. I came to Baripada hospital. I saw Lakshmi Priya being admitted in the hospital, having sustained burn injuries over her belly and chest. She was unable to speak, but she was simply seeing us. I came to Baripada Town PS to lodge a report on 22/4/2000, but the officer in charge did not receive the report on the ground that my daughter had not died at that time. At about 11 p.m., police of Baripada Town PS and one executive magistrate had come to the hospital. I could not hear what my daughter was telling to the police and magistrate. I took my daughter to Tata Hospital at about 12 p.m. to 1 a.m. night. At about 8:30 or 9 p.m., when my daughter was in the hospital, I inquired about the cause of her suffering. My daughter told that she had burned herself, pouring kerosene on her body, as she could not tolerate the ill treatment and torture made by the accused person.
So this is their this oral dying declaration is also.
Oral dying declaration.
But whatever she has stated
Hello.
before PW3, that is the oral dying declaration, that runs contrary to the written dying declaration by PW4. ଏଠି ସେ କହିଲା ଯେ ମତେ ମୁଦାଲା ମାନେ ନିର୍ଯାତନା ଦଉଥିଲେ ଯୋଉଥିପାଇଁ ମୁଁ ମୋ କିରୋସିନ ପକେଇ ମୁଁ ନିଜେ ପୋଡି ହେଇଗଲି. Whereas in the written dying declaration she has stated that ଶାଶୁ ଆଉ ସେ ଯୋଉ
personalize କରିଥିଲେ
ଖୁଡି ସେଇମାନେ ମତେ ସକାଳୁ ଗାଳି କରୁଥିଲେ. ଗାଳିର କାରଣ କିଛି କହିଲାନି, ଅନ୍ୟମାନେ ମତେ କିଛି ଗାଳି କରୁନଥିଲେ. ତେଣୁ this runs contrary to the written the dying declaration that is marked as exhibit 7. So oral DD version runs contrary to written DD white exhibit 7 na?
7.
Okay. Continue.
The torture part was there, my lord. In written dying declaration, he has specialized two accused persons. But here he has
that is contrary. In that way, it is contrary. That he has implicated, she has implicated everybody, all the accused persons, whereas only two have been named in that.
There, my lord.
Right. Okay, continue from paragraph 10.
My lord, after admission of my daughter in Tata Memorial Hospital, I returned to my village to collect money for her treatment. On 22/4/2000, I lodged written report at the PS. One Mahadev Das scribed the report as per my instruction, and I put my signature after going through the contents of it. Exhibit 2 is that report. Exhibit 2/1 is my signature. Police seized the discharge certificate, articles given as per list, etc. on my production and prepared seizure list wide exhibit 5, exhibits 3 and 4. Exhibits 3/1 and exhibits 4/1 are my signatures. Police gave me the sealed articles in my Zima for Zimanama wide exhibits 5 and 6. Police also seized the articles as per list wide exhibit 6 and gave in my Zima. On 26/4/2000, Lakshmi Priya died in the Tata Main Hospital. On 27/4/2000, postmortem examination was conducted. Rasbihari, father of the accused, Prahlad, received the dead body of the at Baripada.
Okay.
I was interrogated by police in the matter in cross-examination. The date appearing in the FIR has been corrected. I have corrected the date, though I had given the date 24th, but subsequently I have corrected it to 22nd. I have also corrected the date on the body of the FIR. It is not a fact that the FIR was lodged on 24th.
But that again come to the FIR. Where the correction has been made, let us see.
Last part of the signature, my lord, where format put signature.
अच्छा हाँ 24 टा 22 कर दिया जाइए क्लियर पूरा प्रोमिनेंट जଣା पड़ुଛି ଆଉ ଗୋଟେ ଏଠି ମଧ୍ୟ ଏଣୁ ଯୋଉ ବିନୀତ ଅନୁରୋଧ କରେ ଏହାର ସତ୍ୟ ତଥ୍ୟ ଅନୁସନ୍ଧାନ କରି ସେଥି ମଧ୍ୟ 22 ଟାକୁ 24 ଟାକୁ 22 କରାଯାଇଛି ତା ଛଡା एफआईआर टा मजिस्ट्रेट को पाखरे पहुंची ऊपर फ्रंट पेज रे मजिस्ट्रेट को सिग्नेचर अछि
yes my lord that is
25 25 4 लगा है
25 4
हां ता माने एटा 24 रे यही छी अब 24 रे किन ता 22 करचंती हो but there is something here this number 1097 এটা 23/4/2020 कहउची 23 যদি এটা হলো তাহলে but it reached SDGM on or it was placed before SDGM on 25/4. Okay, you are placing the evidence of PW2 3
cross examination.
Cross examination. Read out this.
My lord. There are about 70 to 100 houses at village Kamta, house of Adibandhu Mahapatra, Birokishore Behera, Rajkishore Behera, Raja Naik, situate near my house. None of my villagers were present when there was finalization of marriage proposal. Banko Behera, the mediator, was present at that time. No list was prepared in respect of the articles to be given by us. Banko Behera was not present when cash of 11,000 was given. Except my relation, Nakula Behera, no other relation was present when money was given. Cash was drawn from the bank. I had not given any document to police in support of withdrawal of money. The marriage proposal was finalized within 5 days. I had not gone to the house of the accused persons within those 5 days. None of my relations or family members had also gone to their house. Grandmother of the accused Prahlad had died during that period, and during that period, accused Parmeswar and Govinda had gone to our house to settle the proposal. I had given the articles as per the list of my own accord. I had no talk with father of the accused Prahlad or Prahlad within those 5 days. Accused Parmeswar and his wife were living separate in mess and property from Rasbihari. It is not a fact that accused Gobind was living separate in mess from his brother. Accused Prahlad during that time. I have mentioned in the list of articles about giving up cash of rupees 11,000 myself, and Rasbihari have signed in that list. I had received telephone ring once from Lakshmi Priya from the date of marriage till her death. Lakshmi Priya had told that she had made the telephone from the house of a neighbor. Signature of Lakshmi Priya is not available on the letter delivered through a female to me. So also the date. There is no mention in that letter that Lakshmi Priya was being ill-treated due to non-giving of dowry articles. Accused Prahlad had not complained before me on those 3 occasions when he had come to my house with Lakshmi Priya about non-giving of any dowry article. Lakshmi Priya had come to my house about 1.5 months prior to her death with her husband for the last time. I had talked twice with Govinda in his house after marriage. After 5 months of the marriage, the above talk took place. I had no talk with accused Parmeswar and Govinda within 5 months of marriage. I have got other agnatic relation in the village of the accused persons. Since I was serving outside, I had no occasion to go to their houses. I had gone to the house of the accused person 2 to 3 times. I cannot say who are the neighbors of the accused Parmeswara and Rasbihari. I had not told anything concerning ill treatment or death of my daughter. No other neighbor was present in the house of the accused person. when I came to their house on 21/4/2000 at about 9 a.m. Rasbihari and accused Prahlad were not present in the house when I reached. Only Nakula Behra had accompanied me to the house of the accused person on 21/4/2000. I stayed from 9 a.m. to 1:30 p.m. In the house of the accused person on that day. At about 11:30 p.m., police came to the hospital. I had not given any written complaint to the police at the hospital. I have not mentioned in the report that there was demand of 25,000 from the side of the bridegroom, and it was finalized at 11,000, and that accused persons demanded payment of 11,000 3 days prior to the marriage. And that accused Parmeswara and Govinda took 11,000 3 days prior to the marriage from me through Sudhanshu, and that Nakula, Sudhanshu, and Dhanardhan were present at the time of payment of above 11,000. And that, as per the invitation of accused Parmeswara and Govinda, my son and two others had gone to the house of the accused persons on the Chaturthi, and that at the time of Bahuda, accused Prahlad had come to my house with Lakshmi Priya, and accused Prahlad was asking Lakshmi Priya to demand the other articles, and that on the next day, father of the accused Prahlad brought Lakshmi Priya and accused Prahlad from my house, and that accused Prahlad had come thrice with Lakshmi Priya to my house.
So that
and was
FIR contents has been confronted. That whatever you have stated in the chief examination, that is not there in the FIR. And he admits that. That is correct. But he has mentioned that I have not mentioned. He admits that it is not there. Okay, so
that was confronted.
Just, okay. Then you come to this paragraph 25.
My lord, it is not a fact that I have stated before the IO that after marriage, Lakshmi Priya used to come to my house once or twice in a month along with her husband, and the couple used to enjoy a happy marital life, and that I could not say the reason for the quarrel between the couple. It is a fact that I have stated before the IO that on 21/4/2000 at about 9 a.m., when I came to the house of the accused persons, saw non-availability of bangles and sankha in the hands and vermilion on the forehead of Lakshmi Priya. And when I inquired about the reason, neither Lakshmi Priya nor accused Prahlad disclosed anything about the matter.
So this statement, the first one, he denies that it's not a fact.
Yes, sir. Yes, sir.
But the
subsequent
he admits that I have not stated. That means the statement which he has made in the chief examination that when I came on 21/4/2000 at 9 a.m. to the house of the accused persons, there was no bangles in the or sankha in the hands and vermilion on the forehead. So then there was an inquiry to the deceased, and but he admits to not to have stated.
He has stated, my lord. It is a fact that I have stated before the IO. What's the subsequent?
Okay. It is a fact that I have stated already. I have stated before the. It is a fact that I have stated before the IO that on so and so, when I came to the house of the, saw non-availability of bangles and sankha in the hands of and vermilion on the forehead. And when an inquiry about the reason, neither Lakshmi Priya, acha. ସେମାନେ କିଛି କହି ପାରିଲେନି ବୋଲି କହିଲା, କିନ୍ତୁ ଚିଫ ରେ କଣ ସେ କହୁଛି ଯେ ଆସି ଯେତେବେଳେ ପହଞ୍ଚିଲା ଏ ଦେଖିଲା ଯୋଉ ଇଏ ନାହିଁ, ଚୁଡ଼ି ନାହିଁ କି ସିନ୍ଦୁର ନାହିଁ.
That is that.
Paragraph 8.
Paragraph number
8.
8. अच्छा. Paragraph number so my daughter made a telephone call. We reached there, found no vermilion mark on the forehead of my daughter. Bangles and shankha were also not there in her hands. My daughter cried, and wife of Govinda took Lakshmi Priya inside. Okay, then what has happened? You are reading the cross-examination, paragraph number 24-25 wala. All right, read paragraph 26.
My lord. Sibo Behra is a co-villager. House of Sibo is situated near the school where Lakshmi Priya was reading. It is not a fact that since Lakshmi Priya had affairs with said Sibo, I hurriedly performed the marriage with accused Prahlad, and that Sibo was frequently going to the house of accused Prahlad to meet Lakshmi Priya after the marriage, and that when the affairs came to the light, Lakshmi Priya committed suicide by pouring kerosene on her body. It is not a fact that there was no such payment of 11,000 as demand, and that Lakshmi Priya was being subjected to ill treatment and harassment after the marriage, demanding gold ornaments, furniture, and other articles. Accused Parmeswar had married in my village. It is not a fact that I am not in visiting terms to the house of the father-in-law of the accused Parmeswar due to ill feeling, and that for that reason I am not pulling on well with accused Parmeswar and his wife. I have not made any complaint before the higher authorities when the OIC Baripada Town PS did not receive written FIR from me and for the first time. I have not mentioned specifically in the FIR about giving of cash of 11,000, but I have mentioned that articles worth 70,000 had been given as dowry. It is not a fact that the cash of 11,000 and other articles, as per the list, had not been given to the accused Parmeswar.
Okay. So if we, Mr. Mahapatra,
My lord.
so let us first come to the higher offense,
My
that 306.
my lord.
So
306 is lesser than
say Ratanlal Dirajlal Kanalpur, 102 Tadi. All of it.
it is lesser offense, my lord, than 304. For that, without framing specific charge on that, man, Lord court below convicted.
Three 306, it starts with that if any person commits suicide, whoever abates the commission of such suicide shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. This word abates, which is there, it is also there in section 108
Yes,
of the Indian Penal Code.
yes.
Give the IPC. Now, abatement has been defined in 107,
Ma'am.
and who is an abater, that is defined in
108.
108. So a person abates the doing of a thing who, one, instigate any person to do that thing,
Ma'am.
engages with one or other person or persons in any conspiracy for doing of that thing. If an act or illegal omission takes place in pursuance to that conspiracy and in order to doing of that thing, then intentionally aids by any act or illegal omission the doing of that thing. A person who by willful representation or by willful concealment of material fact which he is bound to disclose voluntarily causes or procures or attempts to cause procure a thing to be done is said to instigate the doing of that thing. Then explanation 2 is important. Whoever either prior to or at the time of commission of act does anything in order to facilitate the commission of the act and thereby facilitate the commission thereof can be said to alight. A person abater, a person abates an offense who abates either the commission of the offense or commission of an act which should be offense if committed by a person capable of law committing an offense with the same intention or knowledge as that of the abater. It reads like this, that the abatement of suicide involves mental process of instigating or intentionally aiding a person in doing of a thing. There should be clear mens rea to commit offense under section 306. It requires commission of direct or active act by the accused which led the deceased to commit suicide, seeing no other option, and such act must be intended to push the victim into a position that he commits suicide. So, suppose the two ladies, that is, one is mother-in-law, the other is the aunt-in-law. They were abusing this deceased from the morning. And we are not sure what is the reason for such abuse, because the deceased herself has stated before the magistrate that she did not disclose the reason, and it was not, of course, dowry.
Yes.
For dowry. So in such situation when two ladies are abusing another lady, can it be said that they abated the commission of suicide of that lady or the deceased?
Explanation of 108, Lordship, kindly say. To constitute the offense of abatement, it is not necessary that the act abated should be committed or the effect of requisite to constitute the offense should
No,
be
that's a different thing. Suppose X abets Y to commit murder of Z. Even if Y does not commit it, but it will still amount to abatement. Okay. So that is there. But here,
no, that is, my lord, my submission is, my lord, that is applicable to other, in view of the evidence of PW3, the father, my lord, he oral dying declaration, all the family members were torturing.
No.
That is, my lord,
First of all, you see, what has happened in the past, it's not what has happened on that particular day. The deceased, why she said that I committed suicide. I committed suicide because since the morning, these two ladies, my mother-in-law and my aunt-in-law, they were abusing me. So that is why she has stated that my husband and other, they have not done anything to me. So this statement which has been given by the father, it runs contrary to the dying declaration. So we are concerned, let us say that she has also stated against her mother-in-law and aunt-in-law that they were abusing. Can it be under section 306?
Amount to
Abatement of commission
of offense.
So suppose somebody takes is an exception. Okay. Somebody is abused for a particular purpose. So let us say in day to day, in domestic quarrel also happens. A lady takes it as an exception, commits suicide. Okay. Like suppose a girl is abused for her poor performance in the exam, and she commits suicide. So can it be said that the parents who abused her for scoring these poor marks are the abettors of the commission of suicide? So there must be proximate link.
Yes, ma'am.
So they were not abusing for her to commit suicide. They were abusing her because she scored less mark in the examination. So that is why it says that you see, an indirect influence, this is most important, an indirect influence or an oblique impact which the acts or utterances of the accused caused or created in the mind of the deceased and which drove him to suicide will not be sufficient to constitute the offense of abatement of suicide. Beautifully it is stated. An indirect influence. So I abused him for something. It has got some kind of influence and or an oblique impact which the acts or utterances of the accused caused and created in the mind of the deceased and which drove him to suicide will not be sufficient to constitute the offense of abatement of suicide. A fatal impulse or an ill-fated thought of the deceased, however unfortunate or touchy it may be, cannot unfortunately toss the issue. The ingredients of for abatement of suicide will be satisfied only if the suicide is committed by the deceased due to direct or alarming encouragement or incitement by the accused, leaving no option but to commit suicide. Further, as the action of committing suicide is also on account of great disturbance to psychological imbalance of the deceased, such incitement can be divided into two broad categories. One, normally where the deceased is having sentimental tie or physical relationship with the accused, and the second category where deceased is having relations with the accused in official capacity. So what it says that there must be clear mens rea,
Yes,
right?
That there it leads to the deceased to commit
Right. So
suicide.
there was some kind of abuse. What is the nature of the abuse? Whether it is for domestic that quarrel, whatever it has happened, they abused, or so that is not clear. So merely
That
because
is
she took it as an
lots-
exception, if we say that it was going on, she was mentally disturbed and she took that extreme step.
That is my PW3 statement is that
Yeah.
8 to 10 days, 10 to 12 days. My lord, lots of kind have a glance again to PW3. That is page 80. 10 to 12 days prior to the death of Lakshmi.
88.
80, 80.
80. ନାଇଁ ପାରାଗ୍ରାଫ କୁହନ୍ତୁ ପାରାଗ୍ରାଫ ମୁଁ ଧରିଛି ଯୋଉଟାରେ ସେଟାରେ ପେପର ବୁକ୍ ପେଜ ନୁହେଁ ସେଟା ଇଏ ପେଜଟା ଏଲସିଆର ମୁଁ ଦେଖୁଛି ପାରାଗ୍ରାଫ କେତେ
Paragraph 6, sorry.
ଆପଣ evidence of, are you reading evidence of PW3? So tell me the paragraph number.
6, paragraph
6. Okay.
That is the letter. My lord, prior to that, torture was there.
No, later, you see, later has not been produced in court. You said that a letter was seized.
Next, my lord, after receiving the letter, paragraph 7, after receiving the letter, I went to the house of accused persons along with Sudhanshu, my lord, PW1. Reached at 8 p.m. when the daughter started crying, seeing the accused Kati and seeing us. Accused Kati and Sunni pushed her inside a room and closed the door. When Sudhanshu Giri inquired from Lakshmipriya as to the reason of for the dispute, she told that the accused persons were demanding gold ornaments and she was being ill-treated for non-giving of the same. Lakshmipriya further complained that she was not being given food to eat and was being assaulted by the accused me and Kati.
So all these things, admittedly, he has not mentioned in this FIR, which you say that it is not an encyclopedia.
Yes,
he also admits that yes, I have not stated.
That corroborates from the evidence of PW1 laws.
So that incident was 10 to 12 days prior to the death. See, they received a letter which has not been proved.
That finds corroboration.
Just a minute.
Well, that
So that
that fact, my lord, finds corroboration from the evidence of PW1, who accompanied the PW3, the father, to the house of the deceased, in-laws house of the deceased.
who you say?
PW1, my lord.
I went to the house of the accused persons along with Sudhanshu. Sudhanshu is
PW1, my lord.
And Koji Audaki and reached there at 8 p.m.
My lord.
When my daughter started crying, seeing us, accused Scotty and Sunni pushed her inside a room and closed the door. When Sudhanshu inquired from Lakshmi Priya as to the reason for the dispute, she told that the accused persons were demanding gold ornaments and she was being ill-treated for non-giving the same. Lakshmi Priya further complained that she was not being given food to eat and was not assaulted by the and was being assaulted by so and so. This is ଏଇ ଯୋଉ ଯୌତୁକ କଥା ଜିନିଷ ପାଇଁ ତାକୁ ଯୋଉ assault ହଉଥିଲା, first of all that has been the charge has failed, that 304B is not there. Even the dying declaration se clearly କହୁଛି ସେ ଯୋଉ particular line ଟା,
with regard to demand of dowry.
ହଁ ଯୌତୁକ ପାଇଁ ମତେ କେବେ ଗାଳି କରିନାହାନ୍ତି.
That is there.
Then acha, if you come to the evidence of PW1,
page 70, my lord, 70.
paragraph 4.
Paragraph 4, yes, ma'am.
ଏ ଯୋଉ PW 3 ର ଯୋଉ evidence ଅଛି, ସେଇ particular line କୁ ଆସନ୍ତୁ, page 81 ଯୋଉଟା କହୁଛନ୍ତି. When Sudhanshu Giri means PW1, inquired from Lakshmi Priya as to the reasons for the dispute, she told that the accused persons were demanding gold ornaments and she was being ill-treated for non-giving of the same. Lakshmi Priya further complained that she was not being given food to eat and was being assaulted by accused Sunni and Kati. She further told that accused Prahlad was also assaulting her. So these are the statement which the deceased stated to have been made to PW1. Now let us say what PW has stated. One has stated. PW1 stated that I entered into the room. She complained before me that accused persons were ill-treating her for not giving those articles. Those articles means
demanded articles.
Let us say demanded articles. But all these things, she was not given food to eat assaulted by.
That is not there in evidence of PW1. That is not
So
there.
how you say
With
that
regard to
it is not corroborating the evidence of incompletely?
the narration melody is not there.
No. Anything about anybody not providing food.
That is, my lord, my submission is that is, my lord, ill treating. That is the accused persons PW1, my lord.
ଆପଣଙ୍କର ଯୋଉ demand of ଇଏ that has been already disbelieved.
Yes.
There is no charge also.
Yes. No charge.
There is no charge. That part has been disbelieved.
No.
Now you are to prove other kinds of torture. And that other kinds of torture is, let us say, they were not providing food or assaulting. এই যে লাইট রে যে আসিলা যে she was being ill-treated. For Lakshmi Priya further complained that she was not being given food to eat and was being assaulted by Suni and Kati.
That is the father
এই স্টেটমেন্টটা ফাদার কହୁଛି फादर कौची किए पचारला ना PW1 पचारला टू से कथाटा कहला PW1 ए विषय टोटली साइलेंट अछि
से कथा करूनी
ताले how do you say that a case under 498A will be made out?
My lord, that is PW1 statement is I entered into the room Lakshmi Priya of room of Lakshmi Priya and she complained before me that the accused persons were ill treating.
Just general statement dela.
My lord.
ତେଣୁ ଦି ଜଣଙ୍କ ପ୍ରେଜେଣ୍ଟ ଦି ଜଣ ସେ ବିଷୟରେ କହୁଛନ୍ତି ଏବଂ ଦି ଜଣ କହୁଛନ୍ତି ଯେ PW1 made a query to the deceased and the deceased told like this.
Other statement elaborating all this, but
that is why if one part of that has been already disbelieved by the trial court, there is no challenge to that part. You are not challenging 304P acquittal. So only thing remains that if, because 498A says that the cruelty, that definition which is there in the explanation, it says like this, that any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life or limb or health, whether mental or physical, of the woman. Then B, harassment of the woman, where the harassment is with a view to coercing her or any person related to her to meet any unlawful demand. That has already been disbelieved. Okay, so first thing is, second, B is not there here. Now A, if you will find, the willful conduct must be of such a nature as is likely to drive the woman to commit suicide. Okay, so suppose the statement comes that 8 to 10 days prior to the date of occurrence, father of the deceased is PW3 and one co-villager, that is PW1. They visited the house of the deceased. Why they visited? The reason is that they got a letter. They got a letter which states about the ill treatment to the deceased. That letter has not been proved by the prosecution, though a seizure list is there. So we are, that means everybody was kept in darkness as to about what is the contents of that letter, right? So if you say that that letter was the reason for which the PW1 and PW3 visited the house of the deceased,
That
then
should have been proved.
then it should have been proved,
Yes.
because that was the reason for
Yes,
which
yes,
they.
ma'am.
So that means there was something in that letter
Yes.
which compelled them to go to see what is the condition.
My lord, ma'am.
So if you are withdrawing that letter, that's a vital piece of
That I
so that so next thing is that when two persons are visiting the house and one person is asking the deceased that what has happened to you, he's telling that the accused persons were ill-treating me for not fulfilling the demand of articles. So the other person is telling that they are not providing food, and two of them were assaulting him, all these things. So is it not that one witness statement is contrary to the other, particularly when that part of demand has already been disbelieved by the trial court? There is no charge under 4 DP Act.
Yes.
So how will you convict a person and under 498A in this circumstance? There is no other witness.
My lord, PW2 is the brother. He states like this, my lord, prior ill treatment. And also PW7.
No, come to PW2. You said PW2, come to PW2 about the torture part, because we are now concerned with torture
Yes, ma'am.
and if anything about the suicide. So torture part, what he has stated, because the other things, this dowry articles, etc., demand that has already been disbelieved.
Yes.
No charge is also there. So we have to focus on torture part. So what this PW 2, the brother of the deceased, has stated about the torture part.
My lord, paragraph 2.
So read it.
My lord, I on 12/1/2000, I had gone to the house of accused Prahlad.
You are reading evidence of?
My lord, PW2.
Yes, sir. That is, my father had gone to the house of.
My lord.
Okay.
My father had gone to the house of accused Prahlad during Durga Puja to bring Lakshmi Priya home, but accused persons did not allow Lakshmi Priya to come with my father. On 12/1/2000, I had gone to the house of accused Prahlad to bring Lakshmi Priya to our house, but she was not allowed to come. Accused Prahlad told that Lakshmi Priya would be allowed to go after delivery of all dowry articles. When Lakshmi Priya wanted to come with me, accused Prahlad pushed her inside into the room and bolted the door. I had gone 4 to 5 times after 12/1/2000 to the house of accused Prahlad, but I was not allowed to talk with Lakshmi Priya as she was being kept in a room bolting the room from outside.
So one incident took place, according to him, on 12/1/2000.
Yes, ma'am.
This incident is not deposed to by any other witness.
No, ma'am.
PW1,
that is
PW3 is my father.
Yes.
So obviously, suppose on 12/1, brother had gone to the deceased house, and this thing has happened, that he wanted to bring his sister, and he was not allowed, and the sister was pushed and the door was bolted.
This incident also required to be taken in evidence of PW3, at least father, my lord.
Right,
Yes,
because
it
is very natural that he will come to the house and tell his family members that this thing that I had gone to bring my sister and this thing has happened.
No, that is not.
But the father's evidence is completely silent about the incident dated 12/1/2000. PW2 is the brother.
Brother, man.
So he first tells about the incident dated 12/1/2000, right?
Well,
That is not supported by PW3.
see.
Okay, then what he has stated? Then he tells about the that 21/4.
Prahlad told that Lakshmipriya would be allowed to go after delivery of all dowry articles. That demand of dowry articles, my lord, which was then made by PW1 and 3, my lord, it finds corroboration from that. Though it is omitted in the evidence of PW3, my lord, but it finds corroboration the demand of dowry that is there, my lord.
That is not. There is no charge. There is no. That has been. Okay. Come to the evidence of paragraph number 3.
Well,
of the PW2's evidence on 21/4/2000.
2020.
Read it.
At about 8 a.m., Lakshmipriya had made telephone call to our house and requested us to come to take her back from her house of accused Prahlad. Lest she would be killed. On that day, my father and Nakula Bera went to the house of accused Prahlad. Accused Parameswara and Govinda assured my father to settle the matter in the family and to leave Lakshmipriya after some days. On that day evening, somebody informed us over telephone that Lakshmipriya had been hospitalized.
ये जो बापा तार जाइथिला बेले से कहूची बापा हला PW3
and Nakula is PW7.
अच्छा से बापा एविडेंस टाको आगे आसन
Page 81, paragraph 8, Lordship.
You see, what PW3 has stated in page 81, paragraph number 8.
There is a wrong date has been mentioned, 21.
This is one. No, that is. Let us say that it is 21. Let us go for that. But what he has stated that taro କପାଳରେ ସିନ୍ଦୁର ନଥିଲା, ତା ବ୍ୟାଙ୍ଗେଲ୍ସ ଭାଙ୍ଗି ଯାଇଥିଲା, ତାର ଶଙ୍ଖା ନଥିଲା, ମୋ ଝିଅ କାନ୍ଦୁଥିଲା, ତେଣୁ ଏମାନେ ମତେ କହିଲେ ଯେ ଆମେ ତାକୁ ବୁଝାବୁଝି କରିକିନି ଇଏ କରିବୁ, ଆଉ ଏଇଟା ହଉଛି ତାଙ୍କର ପରିବାର କଥା, ଫ୍ୟାମିଲି ଆଫେୟାର୍ସ। ଆଉ ଯେତେବେଳେ deceased Lakshmipriya wanted to see us, accused Kati gave a push to Lakshmipriya and put her inside the room. Accused Kati at that time said that Katha koile saribane. So all these things are stated to have happened on that day. But you see that only thing what has been stated by PW2,
that is not
that my father and Nakulo, they went
to the house of
accused Prahlad. And this later part has also been not stated by this PW2.
That is not there. That is not.
Yeah. Okay, let us come to that other witness, PW7, na?
7.
ସେଇ ଦିନଟାକୁ ପଳେଇ ଆସନ୍ତୁ।
Madam.
21/4
Paragraph 2, madam. Yes. On 21/4/2020, my uncle told me about sending of information to him towards ill treatment of Lakshmipriya. This is the regarding letter.
Yes, yes.
I accompanied my uncle to the house of the accused persons. I did not find bangles and a vermilion on the body of Lakshmipriya. Accused Parameswara and Govinda came, and in their presence, Lakshmipriya told about the nature of ill treatment shown to her. When we impressed upon the accused persons about our intention to take away Lakshmipriya from their house, they assured us to settle the matter as it is as a misunderstanding among the family members. Lakshmipriya told to come with us as she apprehended that she could be killed. Accused Kapti at that point of time put forth the concerning the gold ornaments. They are also abusing us and Lakshmipriya during that time. Due to intervention of the accused Parameswara, female accused persons sent away from police. Accused persons told that he would leave Lakshmipriya to house, and after morning next paragraph.
What he has stated in the cross-examination. Cross-examination, you see.
Lordship.
Paragraph 9.
Madam.
I had not come to the house of the accused prior to the date of marriage. Gala?
Madam.
I had gone to the house of the accused on the date of marriage and accompanied my uncle on 21st. So, accused Prahlad had gone twice to his father-in-law's house accompanied by Lakshmipriya. They had never come to our house on the above two occasions. I have never met accused Prahlad during the above occasions. I had not asked anything to accuse Prahlad with regard to demand and ill treatment. I had gone to the house of my Piyush Gishara. After 3 to 4 days of marriage, it's not relevant. I do not know. Acha. Third line, accused Rasbihari and Prahlad were not present in the house when he came on 21st. You see, that means only when they reached there, these two persons were not present. Accused Rasbihari were not present in the house when we came on 21st. Accused Prahlad came subsequently. We had a talk with accused Parameswar after our arrival. Accused Govinda, the elder brother of the accused Prahlad, came while we are talking with accused Parameswar. Parameswar ki hai?
Parameswar, my lord, Dada, uncle-in-law.
This is that is
accused 3.
Sorry, number 4, uncle-in-law. I cannot say if any outsider was listening to our discussion in the house of the accused persons. I had not seen any injury on the body of Lakshmi Priya after arrival in the house of the accused persons. It's not a fact that I have not stated before the IO that after our arrival, Lakshmi Priya told us that I have not stated, hala, eta bhartiyo. It's a, acha, he admits it. It's a fact that I have, that means he admits that I have not stated before the IO that after our arrival, Lakshmi Priya told that she was being assaulted by the accused persons in the night and they were demanding ornaments and other articles. So this was not there in the previous statement. First time he has stated it.
Yes.
And out of context, paragraph 4 रे कौन लिखा ला? It is a पढ़ियोनु. देखियो एटा. PW2 तो नहीं PW7.
7.
And there is threatening to her life. And and that she admits.
This is a suggestion that was
No, not suggestion.
To the police.
The 161 statement was read out.
Yes.
To the witness.
That has been confronted.
Confronted. He said that yes, I have not stated.
Yes.
That means this is the statement that this is told like this. That is that was not first time it is stated.
Yes, ma'am.
So okay. PW7 what are the other evidence?
These are the evidence. Mostly,
who is 9? PW9?
9 is the, my lord, IO was concluded the investigations.
Okay. PW8?
8 is the initial.
Okay, he handed over the charge of investigation to PW9, right?
Yes, my lord.
Then 7?
7 is discussed, lordship kind. He had
Achha, 7. 6 is I examined
the doctor, my lord, who treated the accused.
Oh, he had also sustained burn injuries.
Burn injuries.
Then PW5?
5 is the doctor who treated the deceased.
Deceased, okay. 4?
4 is the executive magistrate.
That recorded that dying declaration. Then 3,
1, 2, 3, and 7, my lord, the prosecution witnesses, those who have established the torture, demand, and other things.
3 is that informant, that father. 2 you said that he is the brother.
PW2, my lord.
Right. And 1 is that co-villager. Accompanied. I'm just coming. I will decree the judgment. Please sit down. What is your name?
My lord, Gaurav Das.
এটা কোন ঠিক আছে হলো স্টেটমেন্ট বি ছোট বড় ক্যাপিটাল আছে এবিটি চলো The appellant number 1, Prahlad Behra, the husband comma appellant number 2, Govinda Behra, is the elder brother-in-law, bracket husband's elder brother. Appellant number 3, Draupadi Behra, the mother-in-law. Appellant number 4, Parmeshwar Behra, is the uncle-in-law. And appellant number 5 is the aunt-in-law of the deceased, Lakshmi Priya Behra, respectively. All the appellants face trial in the court of Learned Additional Session Judge, Fast Track Court, Baripada, in ST number 50 of 50/214 of 2002. For commission of offences punishable under section 498A by 34 and 304B by 34 of the Indian Penal Code, on the accusation that they, being husband and other relatives of that appellant number 1 being the husband and the other appellants being the relatives of the husband of the deceased, subjected her to cruelty by willful conduct which was of such a nature as was likely to drive the deceased to commit suicide by demanding more dowry in furtherance of their common intention, and that they caused dowry death of the deceased by burn within 7 years of marriage and that the deceased was subjected to cruelty by them in connection with demand for further dowry in furtherance of common intention. The London Trial Court, by imp judgment and order dated 14/5/2003, has been pleased to hold that the prosecution has failed to establish the charge under Section 304B of the Indian Penal Code. However, found all the appellants guilty under Section 498A and 306 of the Indian Penal Code and sentenced each of them to undergo RI for 2 years and to pay a fine of rupees 5,000 in default to undergo RI for 6 months more under Section 498A of the Indian Penal Code and to undergo RI for 5 years and to pay a fine of rupees 5,000 in default to undergo RI for 6 months more under Section 306 of the Indian Penal Code. And the sentences were directed to run concurrently. The prosecution case as per the first information report, presented by Markand Behera, bracket PW3, the father of the deceased Lakshmi Priya Behera, before Inspector in charge Baripada Town Police Station on 22/4/2000 is that the deceased was his third daughter, and she had married to appellant number 1, Prahlad Behera, on 13/10/1999. In Hirachura Gopinath Temple, Kamaremuna. There was a demand of rupees 70,000 towards dowry from the side of the bridegroom, and appellant number 4, Parmeshwar Behera, was the mediator in the marriage. It is further stated in the FIR that on account of non-fulfillment of some dowry articles, particularly gold ornaments, the deceased was subjected to physical and mental cruelty by the appellants. It is the further prosecution case as per the FIR that on 21/4/2000 at about 8 a.m. the deceased informed her father bracket PW3 that her life was in danger and requested PW3 to take her back. Immediately PW3 and his nephew Nakula Behera bracket PW7 came to the house of the appellants, came to the in-laws house of the deceased, and they found that the deceased has been assaulted and her bangles have been broken and there was no vermilion over her forehead. When they asked the deceased about her condition, she told that since the further demand of dowry could not be fulfilled, she had been assaulted by the appellants. Looking at the condition of the deceased when PW3 and PW7 wanted to take the deceased with them, the appellant number 3 and appellant number 4 appellant number 2 and appellant number 4 appellant number 2 and appellant number 4 assured them that they would leave the deceased at her father's place in Kuliana on 22/4/2000. Accordingly, PW3 and PW7 returned back home. But in the evening hours at about 7 o'clock, a message came from an unknown telephone number that the deceased has sustained burn injuries and hospitalized. Immediately, the informant rushed to Baripada Government Hospital, where he found that the deceased has sustained 60 to 70% burn injuries. When the deceased was asked about the cause of burn injuries, she told that the appellants poured kerosene on her and set fire to her body by using a matchstick. The deceased was immediately shifted to Tata Hospital, when ambulance where she was fighting with death. And it is further stated that the in-laws family members of the deceased had not even come to see her. Suspecting that it's a pre-planned attempt to kill the deceased on account of non-fulfillment of dowry demand, the FIR was lodged. On receipt of Subpara FIR, IIC Baripada Town Police Station registered Baripada Town PS case number 71 dated 22/4/2000 under section 498A307 by 34 of the Indian Penal Code and section 4 of Dowry Prohibition Act. Against all the 5 appellants and directed PW8 Srimati Snigdha Bhanja, SI of Police attached to Baripada Town Police Station to investigate the matter, to investigate the case. PW8 during course of investigation examined the informant, other witnesses, issued requisition to SDM Baripada for deputation of an executive magistrate to record the dying declaration. Requisition was also made to DFSL for deputation of scientific team for inspection of the spot. PW8 herself visited the spot, prepared the spot map, Exhibit 12. He effected seizure of one tin dabba containing some kerosene oil, one burnt matchstick, half-burnt wearing apparels of the deceased, one imitation necklace from the spot, and prepared the seizure list Exhibit 13. She also seized a receipt and other documents granted by Lord Khirochora Gopinath Temple Remuna authorities relating to performance of marriage in the temple premises as per seizure list exhibit 3. And those documents were given in the Jima of the informant as per Jimanama exhibit 5. PW4 Baidyanath Karo, the executive magistrate cum Tahsildar Baripada on 21/4/2000 as per the direction of SDM Baripada recorded the dying declaration of the deceased, which has been marked as Exhibit 7. Stop. The said dying declaration was received by PW8 on 26/4/2000. Stop. On 27/4/2000, PW8 arrested the appellants and they were forwarded to court on 28/4/2000. She also seized the dowry articles as per seizure list exhibit 4 and gave the same in the Jima of the informant as per Jima Nama exhibit 6. The deceased died on 26/4/2000 and who conducted postmortem examination?
PM doctor has not been examined.
And
Postmortem report is exhibit 10.
And inquest was held and postmortem was conducted. And the postmortem report exhibit 10 Where is that? PM report of You should get the copy also. Huh? No, the original FIR must have been sent back, but that copy will be available here. One. Call the person who has sent it back. The postmortem report finding is discussed in the trial court judgment.
Trial court judgment not discussed.
All the cases you should keep like you are keeping in that. Huh? Yes. When the death took place?
The 26th April, man.
26th,
man. Occurrence took place 21st April. Death took place, my lord, on 26th April.
Lord, we have a copy of that PM report.
Awesome. The indicates that the burn injuries sustained were antemortem in nature, and death was due to septicemia and toxaemia of burn. Who is the next IO?
PW9, my lord.
PW8 handed over the charge of investigation to PW9, who examined some witnesses, seized the bedded ticket on 21/7/2001 from DHS Baripada by its seizure list Exhibit 14. On 22/7/2001, he also seized one handwritten plain paper letter and 7 sheets of admitted handwriting of the deceased on production by the informant under seizure list Exhibit 1. On 1/8/2001, he seized the requisition of the IIC made for recording dying declaration of the deceased, made a query to the doctor in connection with the injury sustained by the appellant number 1, Prahlad Behra, the plain paper letter and the admitted handwritings were sent to SFSL for comparison. Along with the seized articles and received the chemical examiner's report. And on completion of investigation, submitted charge sheet. Where is the copy of the charge sheet? Say, say, ये trial court record दीजिए. It on trial court record. Under section 498A 304B 306 by 34 of the Indian Penal Code and section 4 of Dowry Prohibition Act on 3/8/2001. The defense plea is one of denial, and it is pleaded by appellant number 1, Prahlad Behra, that the deceased had illicit relationship with one Sibo Behra, and on 21/4/2000, he caught hold of both of them in a compromising position, for which she committed suicide. In order to prove its case, the prosecution examined 9 witnesses. Give the details. And prove this much of exhibits, give the details. No witness, one witness was examined. One witness, namely Amar Chandra Behera, was examined as DW1. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to hold that in view of the dying declaration, Exhibit 7, the immediate cause for her setting her on fire was not due to any ill treatment relating to dowry articles in connection with the marriage. And there was no such disclosure made by Lakshmi Priya, bracketed deceased, with regard to her ill treatment concerning dowry articles prior to her setting on fire before PW3. It was further held that it is found from the oral evidence that the deceased was not ill-treated on the ground of non-payment of dowry articles in connection with the marriage. And there is no positive evidence that he took the extreme step of burning her body by pouring kerosene due to torture and for non-payment of dowry articles. Accordingly, the London Trial Court held that the prosecution has failed to establish the ingredients of the offence under Section 304B of the Indian Penal Code. However, the London Trial Court held that on the analysis of the entire evidence on record and having regard to the previous attending and subsequent conduct of the appellants, it is found that they wanted the deceased to end her life, and with that end in view, both appellant number 3 and appellant number 5 used foul language attributing to her character on 21/4/2000 money. And since the accusation was labeled against the deceased that she was of loose character, it caused provocation and the deceased took the extreme step to end her life, and therefore the ingredients of the offense under section 306 IPC is proved against the appellants. The London Trial Court also held that the prosecution has successfully established the charge under section 498A of the Indian Penal Code against all the appellants. Mr. Gaurav Das, Land Counsel, appearing for the appellants, contended that the dying declaration recorded by PW4 is totally silent about any role played by the male appellants, that is, appellant number 1, appellant number 2, and appellant number 4. Only thing that has been stated in the dying declaration was that the two lady appellants, that is appellant number 3 and 5, were abusing the deceased since morning. And that was not also in connection with dowry demand. And the doctor bracketed PW4 specifically stated that
PW4 is the executive magistrate.
Executive magistrate PW4 stated that when she asked the deceased about the reason for the females to abuse her, she did not disclose the reason. And therefore, in view of such dying declaration recorded by PW4, it cannot be said that there was any proximate link between the conduct of the two lady accused appellants, that is appellant number 3 and 5, with the commission of suicide of the deceased. And as such, the ingredients of the offense under section 306 IPC are not attracted. The Land Council further argued that the evidence relating to cruelty on the deceased to sustain a charge under section 498A of the Indian Penal Code are discrepant in nature. And though it is the prosecution case that one letter was written by the deceased few days prior to her death, which compelled her father and father PW4 and
PW3 man.
PW3 tatar kon hobo PW3 hala father
informant
ଆଉ ଗୋଟେ ଯୋଉ ଯାଇଥିଲା ତା ସାଙ୍ଗେ
one my lord
ସେ ହଉଛି କିଏ
Sudarshan
କୋ villager ନା
co-villager
and co-villager bracket ରେ PW1 to visit the house of the appellants, but and the said later was seized during course of investigation, and it was also sent to the State Forensic Science Laboratory for examination with the admitted handwriting of the deceased, but neither the report of the scientific officer nor that later was proved during trial. Therefore, the prosecution has withheld a very vital document from the court for which adverse inference should be drawn. The Land Council further submits that there is lack of evidence on record that the conduct of the appellants was of such a nature as was likely to drive the deceased to commit suicide or to cause grave injury or danger to her life, limb, or health, bracketed whether mental or physical. And since the London Trial Court has held that the prosecution has failed to establish demand of dowry, therefore, the charge under Section 498A of the Indian Penal Code is also not established. And it's a fit case where the appellants are entitled to benefit of doubt. Mr. Mahapatra, Lenin Additional Standing Counsel appearing for the state, on the other hand, supported the impugned judgment and submitted that the marriage of the deceased with appellant number 1 was held on 13/10/1999. And it appears from the evidence on record that she was 2 months pregnant as on the date of occurrence, that is on 21/4/2000. And if everything was well, then there was no earthly reason for the deceased to commit suicide, and that too by pouring kerosene on her and setting herself on fire, which resulted in her death. The Land Council further submits that even though in the recorded dying declaration, the deceased has not attributed any overt act against the male appellants, that is appellant number 1, 2, and 4. But the father of the deceased, being examined as PW3, stated that in the hospital when he tried to ascertain the cause of burn injuries from the deceased, she implicated all the appellants in that regard. The Land Council for the state further submitted that even though there are some discrepancies in the evidence of the witnesses, but that is not of such a magnitude to discard and disbelieve the entire prosecution case relating to cruelty on the deceased. And therefore, The Lennon trial court has rightly found the appellants guilty under section 498A and 306 of the Indian Penal Code. Stop. Mr. Mahapatra and yes, Gaurav, I will dictate the rest of the judgment in my chamber, and I have decided to acquit all the accused persons. Okay, because the election petition hearing is there at 2 o'clock. So,
may I take my lord's indulgence to mention a matter, item 75 in the regular list, my lord. It's a hearing matter, my lord.
Yes.
I had requested, my lord, I have filed the paper book.
What is the offense there?
It's a vigilance matter, my lord.
Trap case?
Not trap, my lord.
Disproportionate asset.
Unfortunately, my lord, the day he was supposed to be promoted to SP, that's the day they put him, and then very nothing on record.
What is the disproportionate?
Well, it's not according to them. In the first instance, it was 5 point some odd percent, and then they made it 38 point something. Then 197, my lord, sanction was not granted first, and the authorities indicated that DA should be done, Department Proceeding, DP.
Please, the thing is that there are some parted.
Yes, yes.
So after that we can take up. Please,
I am week after.
You get ready, Mr. You are doing that case.
Which item may I know?
That
75.
75, perhaps Mr. Maharana will be dealing. I will intimate him.
Just intimate.
I will definitely intimate.
Okay. It may not be taken up next week, but it may a week after it will be taken up.
Subject to
Just
lordship's convenience.
exchange the notes so
Yes,
that it would be
yes,
easier. Pinpointedly
Yes.
that how do you meet
Yes.
that disproportionate
Yes.
assets?
Deeply obliged, my lord. I'm so sorry for taking that.
Put a note of appreciation on Mr. Gaurav Das.
Grateful.
have a submission to make. I have filed an interim application. The same copy has been given. The same may be kindly taken up fast. ସେଥିରେ କ'ଣ ହେଇଛି, kindly look to that application.
Yes.
Election petitioner filed an application on 27/4/2023, IA number 13 of 2023. Paragraph 4 may kindly be seen, page 2. That was allowed by your lordship with consent of both the parties. And accordingly, mark kindly come to paragraph 5, page 2. Those downloaded and printed documents made in court have been marked as Exhibit 32/7, 32/8, 33/7, 33/8, 44/7, 44/8, 35/7, 35/8, 39/5, 40/4, 41/4, 42/4, 43/1, 44/1, 45/1, and 46/1. Affidavit uploaded with respect to nomination papers and affidavits in Form 26 of the respondent. Next paragraph. That the respondent in fact has filed his affidavit, revised fresh affidavits in Form 26 on 3/4/2019 before the PW3 on 4/4/2019, which have been uploaded by the PW3 on 4/4/2019 itself in the web portal of the Election Commission of India, but the cover page of the web portal of Election Commission of India with respect to the said uploading of the aforesaid revised affidavit in Form 26 shows the date of affidavit uploaded as a 2/4/2019. That is why there, if your lordship recollects, their consistent case is that affidavit dated 3/4/2019 has been uploaded on 2/4/2019, filed on 2/4/2019. Similarly, to convince your lordship and establish that the first date of uploading does not change, we have sought for to mark as exhibit the affidavit, revised affidavit of Priyadarshana Pavel, which has already been marked as exhibit DP. ସେଥିରେ ବି ସେୟା ହେଇଛି, first date of uploading is 29/3/2019. ଯଦିଓ ସେ ଫାଇଲ କରିଛି 4/4/2019, so that it will clarify the doubt created by them that the first date of uploading does not change. ଏଇ ଗୋଟାକ ଆଣିବା ପାଇଁ ଆମେ 5 ମିନିଟ୍ ଲାଗିବ, ତାକୁ ଖୋଲିକି ଏକ୍ଜିବିଟ୍ କରିଦେଲେ।
କୋଉଟା ଏକ୍ଜିବିଟ୍ କରିବେ?
ସେ ଯୋଉ ପ୍ରିୟଦର୍ଶନ ପାଭେଲର ଯୋଉ
my submission is we'll file a formal objection by tomorrow.
No, he is to be तार affidavit रे गोटे already that has been marked, से गोटा से देखी कहबे काहे कि आपको देरी कर देनी। You are right, you will to close this evidence today.
Yes.
No, they want to download other documents.
No. It is already on. No. It is already on record.
No, my lords. They want to download it further.
Only downloaded to show your lordship that affidavit.
ଯେମିତି ତାଙ୍କ କହିବା ଅନୁସାରେ ହଜୁର ଡାଉନଲୋଡ କରିଥିଲେ ଆମ affidavit ଟାକୁ with consent of both the parties, order is there. ସେମିତି ଆମେ କହୁଛୁ ପ୍ରିୟଦର୍ଶନ ପାଭେଲର affidavit ଟା ବି ଡାଉନଲୋଡ ହେଇକିରି ଏକ୍ଜିବିଟ୍ ହେଲେ
ଆପଣ ଡାଉନଲୋଡ କରିକି
ତାକୁ ମାର୍କ।
So what is the objection? It is available in the EIC ଆପଣ ୱେବ ପୋର୍ଟାଲ ଅଛି, ସେଗୁଡାକ
ଆପଣ with objection ଖାଲି
all right. So it's all right, continue. But Sir is closing the case today, cross-examination. You are to just to file that memo.
Closure memo.
Closure memo.
My lords, what
And
sir
he will
was
give
saying
the
is on
evidence.
Friday he will close. I don't know.
No,
This
no,
is
he
what
will close today. Yes, sir. Sir has told just now. He will close today because there is nothing more to be asked. He has.
ନାଇଁ ମୁଁ କାଲି ଦିନଟା ଯୋଉ ବନ୍ଦ କରିଥିଲି
ସେ ସାର୍ କହୁଥିଲେ ଯଦି
କିଛି
ଦରକାର
ରହିଯାଏ
ହବ ଯଦି କିଛି ଦରକାର ହବ then we will go to, but after going through the details he is saying that I will finish it. So you are just supposed to give your so that sir will give the evidence affidavit of the respondent. All right, please take oath and sit. Please take your seat. এটা যেତେବେଳେ କହିବେ sir ସେ ବାହାର କରିଦେବେ. It will be allowed.
ଆଗେ ବାହାର କରିଦେଲେ
ଆଚ୍ଛା ଏଇଟା କୁହନ୍ତୁ କୋଉଠି absolute. ଆଚ୍ଛା ଲେଖି ଦିଅନ୍ତୁ. IN number so and so ଲେଖନ୍ତୁ. IN number so and so. This is an application. Interim application filed by the respondent today in court, giving copy to the London Council for the election petitioner, wherein a prayer has been made to download and print out the cover pages of web portal of Election Commission of India along with the nomination paper and affidavit in Form 26 of the candidate, namely Priyadarshan Pavel, who was a contesting candidate in the election in question, from the web portal of the Chief Electoral Officer Odisha, that is so and so 8 of Lekhi, and to prove and substantiate the facts mentioned in the application by confronting the same to PW3. The Mr. Milan Kanungal and senior advocate raised formal objection to the averments taken. However, considering the submission made by the London Council for the respective parties and the averments taken in the interim application, I am of the humble view that no serious prejudice will be caused to the election petitioner by allowing such prayer of downloading and printing out the said document. अच्छा এটা লিখি দেবে IAB registered উপরে লিখি দেবে है ना accordingly prayer is allowed, IA is disposed of, the that is to be now proved. এটা
ଆମେ ତାର ଗୋଟେ କପି ବି ଦେଇଛୁ ଡାଉନଲୋଡେଡ ଇଏଟା ପ୍ରୁଭ ହେଇଗଲେ ବେଟର ହବ
କୋଉଟା କହିଲେ just a minute. अच्छा ଏଇଟା ଲେଖିବେ ଏଇଟା order sheet ରେ order ରେ mention କରିବେ as per the order passed. ଏଇଟା ଆଜିକାର ଯୋଉ order ହେଲା IA ଟା ତ ଉପରେ ଲେଖିଲେ as per the order passed in IN number so and so today, the system assistant was asked to open CEO Odisha from the Google, and he opened the same, and then he was instructed to open ceo.odisha.nic.in, and he opened the same. Then he was asked to go to the affidavit portal under the heading of back one, under the heading of election planning, and accordingly ऊपर लिखा है election planning लिखा है he opened the same. Open करो तापर कौन तो कौन then he was asked to open election-May 2019, and he opened the same. And the select and SC-general type election. And then to select Odisha from the select test. Heading. Then he was asked to select the Baravati Cuttack constituency and asked to enter filter. And it is found that in page number 3, click on the এটা কোন এটা জি এটা কোন available ଅଛି আর affidavit টা তার inter nomination paper ରେ there ଅଛି the name of Mr. Priyadarshan Pavel, the candidate who belongs to Socialist Unity Center of India Patriotic Communist Party was is there, and then the system assistant was asked to click on view more inverted comma bhitar rakh debe short, and he opened the same, and then how kon open kariyar achi acha
uploaded
nahi apun eta to pura se print out kar debe au kon then he was asked to download the candidate details as appears on the screen. Tar ote print out karon pura entire page ro print out kar do ଆସିଗଲା ତ ପୁରାଟା ପ୍ରିଣ୍ଟ ଆଉଟ୍ କରିଦିଅ which he printed out ହେଲା এটা ଅର୍ଡର ସିଟ୍ ର ଉପରେ ମେନସନ ହେଇଯିବ ଆରେ ଆକୁ ଦେଖେଇକିନି କ୍ୱେଶ୍ଚନ ପଚାରେ
ସେଇଥିରେ ପଚାରିବି
ଆଚ୍ଛା ଦେନ୍ ଏଭିଡେନ୍ସ ଆଫିଡେଭିଟ ରେ ଏଇ ଯୋଉ ସରି କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଉପରେ ଲେଖିବେ ଯେ ଆପଣ କ୍ୱେଶ୍ଚନ ଫାର୍ଷ୍ଟ କ୍ୱେଶ୍ଚନ ଆରିତରେ ପଚାରିବେ ଆପଣ କରିଥାନ୍ତି ମୁଁ ଡାକୁଛି ଆଫ୍ଟର ଶୋଇଂ ହଁ ବ୍ରାକେଟ ରେ ଲେଖି ଦିଅନ୍ତୁ ତାପରେ ଡାକିବେ ଆଫ୍ଟର ଶୋଇଂ the downloaded এটা downloaded କଣ ଲେଖିବି downloaded downloaded cover page of the election commission of India of the election commission of India of the affidavit with respect to nomination of nomination and form 26 affidavit nomination and form 26 affidavit of candidate Priyadarshan Pavel after showing the downloaded cover page of the election commission with respect to as per the order passed today in IN number your dash of 2023 after showing the candidate was shown sorry the witness was shown the witness was shown SHOWN after showing the downloaded cover page so and so hala tapare bracket end kar and the nomination paper and form 26 with respect sabu jake entire am dekhu the outre dekhundu the witness was shown the downloaded cover page of election commission of India along with the nomination in form 2p and the form 26 affidavit acha along with the nomination in form 2b the nomination in form 2b and affidavit in form 26 of the candidate Priyadarshan Pavel as per the order passed today in IA number so and so. हाँ तापर ठीक है
এটা কোর্টে আমরা লিখেছো
এটা দিবেন आगे सेटाକୁ मार्क ହେଇଯାଉ ତାପରେ ଆପଣ ତ କପି ଦିଆ ହେଇଯିବ ତ ଟୋଟାଲ କେତେ ସିଟ୍ ହେଲା କୁହନ୍ତୁ
एक दुई तीन चार पाँच छः आठ नौ 10 11 12 13 14 15
এটা লিখি দিন after witness was shown the downloaded so and so of candidates parallel পরে লিখি দিন total 17 seats
এটা গোটাଏ କପି ଅଛି
ଆଉ ଗୋଟେ
ନାଇଁ ସେ ଟିକେ ଦେଖେଇଦେବେ ଯାଆନ୍ତୁ ଦେଖିକି
এটা ଦେଖିକି ମାର୍କ କରି ଦିଅନ୍ତୁ
ଆଜ୍ଞା
ତାପରେ it will be provided to you and
ଆଜ୍ଞା
also Mr. Kanun
ଆପଣ ଆକୁ ଦେଖିବା ପୂର୍ବରୁ ଆଗ ଏକ୍ଜିବିଟ୍ ଡିପି ଦେଖନ୍ତୁ ଯୋଉଟା କି ଅରିଜିନାଲ ନୋମିନେସନ ପେପର ଅଫ ପ୍ରିୟଦର୍ଶନ ପାଢେ
ନାଇଁ ନାଇଁ ଏଇଟା ଲେଖା ହେଇଯାଇଛି ବ୍ରାକେଟ ରେ এইটা ଆଉ ଉପରେ କ୍ୱେଶ୍ଚିନ୍ ଟା ପଚାରିବେ ଏଇଟା ମାର୍କ ହେଇଯାଉ ତାପରେ ଆପଣ ନେଇ ଆଣିବେ ସାର୍ ଏଇଟା
ଆଜ୍ଞା
ୟାର ଉପରେ କ୍ୱେଶ୍ଚିନ୍ ଆগে ଏଇଟା ମାର୍କ ହେଇଯାଉ ଜିନିଷଟା
This is the downloaded copy of the cover page of Election Commission of India via portal number https://affidavit.eci.gov.in/candidate/hyphen-affidavit downloaded today by order of this honorable court, and it contains Form 2B of Priyadarshan Pavel and affidavit in Form 26 dated 3/4/2019 of Priyadarshan Pavel.
देखिए देखो
30th March 30/3/2000
so this is the সেটা নিয়ে আসুন সেটা ডাউনলোডেড
copy
সেটা downloaded cover page so and so
সেটটা দেবে কি দরকার
হ্যাঁ
তো সেটটা দেবে কি
ନାଇଁ 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 ଏଇଟା ଅର୍ଡର ତ ରହିଲା ଗୋଟେ ପୁରା ଟୋଟାଲ ଅର୍ଡର ରହିଲା ପୁରା this is the downloaded cover page of the Election Commission of India along with so and affidavit in form we bracket লিখুন total seat লিখুন total 7 seats এটা আউটসাইড লিখুন হ্যাঁ
डबल
ना 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 सीट को आउची सीट माने एरा सब साइड में हां 17 सीट मार्क्ड एज केते सर आपण तरफ मार्क हो
एग्जिबिट डी यू हबो डी टी जाने
देखो
डी डी यू बोधे जाईची देखो
डी यू हम पढिथान एटा डी डी पर
अच्छा एटा कोन हबो
डी यू
डी
ठीक तो डी यू
देखि दो डी पर यू
ठीक है स्टॉप सर तरफ पहुंचाओ
देखंतु एटा कवर पेज
आगे
ए कवर पेज लिखा हिची affidavit uploaded on 29th March 2019
आगे
ते इसे कवर पेज स्टडी बाहर कर लो हां आणि चेक करो हां कोड लिखा हिची कोन दो
माय लॉर्ड affidavit डॉट हेडिंग अछि
कोन दो
लेफ्ट हैंड साइड रे मध्य रे
हां एटा
affidavit uploaded
अच्छा in the cover page of exhibit DU it is mentioned that the affidavit uploaded, it is mentioned that the affidavit was uploaded on 29th March 2019.
The cover page may be marked as exhibit DU by 1.
The said cover page is marked as exhibit DU by 1.
And the portion showing affidavit uploaded as 29th March 2019 be marked as exhibit DU by 2.
And the portion showing the affidavit uploaded on 29th March 2019 is marked as exhibit DU by 2.
The form 2B may be marked as exhibit DU by 3.
The form, the nomination form, no? The nomination form
2B.
2B. The nomination form 2B of exhibit EDU is marked as exhibit DU by 3. लिखी दो এটা তো একটা affidavit আছে এই affidavitটা কথা বলি
30/3/2019 বলে লেখা আছে
রাইট 30 দিন
এটা রিভাইজড affidavit
আচ্ছা
the revised affidavit
30 দিন এটা রিভাইজ
revised affidavit in form 26 appearing under
exhibit DU is marked as
exhibit DU by 4.
DU by 4. Stop on.
बटन original nomination paper को नोचे जोटा फाइल करथिले आपन को पाखरे प्रियदर्शन पाभे which has been already marked as exhibit DP with objection DP
T আছে
PP my lord
हां ठीक আছে
এই এটা nomination form संगरे देखंतु भाइड exhibit DP by 1. He has filed the affidavit updated in form 26 updated on 30/3/2019.
Yes, ma'am.
कौन है जी
Nomination संगरे से 29 तारीख रे भी affidavit देखले गोटे
সেটা দেখলে তারপর ওটা রিভাইজড affidavit আচ্ছা the original
stop कर देंगे
stop करें the original nomination paper of the candidate of the candidate Priyadarshan Par which has already been marked as exhibit DT with objection letter DT T na
again DP ठीक আছে
P na T
नहीं P my lord
P अच्छा exhibit DP with objection indicates
contents
अच्छा contents
the affidavit in form 26 of the candidate
the affidavit in form 26 of the candidate
26 पाखरे dated कर दिन dated 29/3/2019
29/3/2019 of the candidate
which has already been marked as exhibit
Rondo contents the affidavit dated for them the affidavit dated ठीक है ना
my lord.
Contains the affidavit dated sworn so in form 26 of the candidate. Yeah, though.
Which has already been marked as
Ajibara Gola?
DP by 1.
Acha. Oh, contents of which has already been marked
As DP by 1 with objection.
Marked.
This is the checklist issued by you on 29/3/2019.
Yes.
Instructing the candidate that his affidavit in Form 26 dated 29/3/2019
সেটা যাইଥିବ ସେଠି ତ ନା
is incomplete.
ସେତେବେଳେ ଯାଇଥିବ ସାର୍ ପଚାରିଥିବେ ସେଟା ସବୁ ଆଚ୍ଛା ନାଇଁ ଏଟା ଖାଲି ଖାଲି
I have given instruction.
ହଁ
as exhibit DP by 1 is incomplete.
अच्छा as exhibit DP by 1 was incomplete, comma
I gave instruction to the candidate.
ଆପଣ ଦେଇଥିଲେ
checklist.
I issued checklist to the candidate. कौन ପାଇଁ ଦେଇଥିଲେ?
On 29/3/2019.
अच्छा on 29/3/2019 कौन ଦେଇଥିଲେ? कौन କରିବା ପାଇଁ? ଦେଖିन कौन checklist
Revised affidavit
to file the
revised affidavit
to submit to submit the revised affidavit
with all columns duly filled up.
With all the columns duly filled up.
Before the commencement of scrutiny of nomination.
Obviously.
Before
the commencement of scrutiny of nomination. तापर कौन हला सी दिले?
In compliance to your instruction.
देखो दिले ज्ञानी
Under exhibit DP by
केबे दिले?
I issued checklist पाखर में लड़ रही वाला checklist number पाखर दे. Exhibit checklist by exhibit DP by 2.
With objection go.
ये आपनकर इंस्ट्रक्शन माने कि से गोटे एफिडेविट सोन करचंती 30/3/2019 रे
आज्ञा
जोटा कि आनी आपन को से 30 दिन न देले
देइचंती 4/4/2019
काई सेरा कोड पाइबा
लास्ट पेज रे सेथे रहइबो पाइबेनी
औ
ए चेकलिस्ट रे पाइबे जोटा आ गोटे चेकलिस्ट देले इन रिसिप्ट ऑफ दी
से चेकलिस्ट रे लिखी चंती जे पाइले बोली
आज्ञा आज्ञा
सेटा 4 तारीख अच्छा I received the revised affidavit from the candidate please जो Priyadarshan Parval
had exhibit DP by 3
ठीक है from the candidate dita double गला Vide
exhibit DP by 3
exhibit DP by 3 with objection on
4/4/2019
अच्छा ये जो रिवाइज्ड एफिडेविट डेटेड कर दियन रिवाइज्ड एफिडेविट डेटेड कर दियन 30/3/2019 है ना फ्रॉम द कैंडिडेट प्रियदर्शन पार्वल बाइड एग्जिबिट ऑन डियर तापरे पाइगिन ता कोन दे
accordingly you have issued exhibit DP by 4 that is the checklist showing the receipt of the
and accordingly I issued checklist by exhibit DP by 4 with objection karantu a to the candidate showing the receipt of the
exhibit DP by 3
showing the receipt of exhibit DP by 3 है ना बस
ए जो एफिडेविट आपण पाइले 4 तारिख दिन फर्स्ट जोटा पाइले 29 तारिख दिन आपण अपलोड करथिले
आज्ञा
in the portal of the Election Commission of India.
Yes.
On the same day, that is 29/3/2019.
आज्ञा
when I received the first affidavit in form 26
bracket exhibit DP by 1
bracket exhibit DP by 1 comma I uploaded the same in the web portal of Election Commission of India on
the same
on
day. The date ta
अच्छा से डेट टा दिन मैंने रिसीव दी पास्ट एफिडेविट इन फॉर्म सेटा ऊपर अवश्य कहिछि जे
dated कर
एफिडेविट डेटेड कर दो
29/3/2019
हां in form 26 I uploaded the same in this one so on on 29/3/2019 हां पचंद
ଯେତେବେଳେ 4 ତାରିଖ ଦିନ ଆପଣ ରିଭାଇଜ ଆଫିଡେଭିଟ ଟି ପାଇଲେ ତାକୁ ମଧ୍ୟ ଆପଣ ପୋର୍ଟାଲରେ ଅପଲୋଡ କଲେ
after receipt of the revised affidavit dated 30/3/2019 नहीं revised affidavit 30 ना 30/3/2019 in form 26 bracket exhibit DP by 3 comma on 4/4/2019 comma I uploaded the same also in the web portal of the Election Commission of India on 4/4/2019 हाँ पचारंतु
ବର୍ତ୍ତମାନ ଦେଖନ୍ତୁ ଯୋଉଟା ଏକ୍ଜିବିଟ DU ହେଲା ଏଥିରେ ଆପଣଙ୍କ ନୋମିନେସନ ଫର୍ମ ପରେ 29 ତାରିଖର ଯୋଉ ଆଫିଡେଭିଟ ଟି अवेलेबल ଅଛି କି
नहीं से तो 30 से आछे रिवाइज वन
ଅଛି କି ଫାଷ୍ଟ वन
नहीं
जोटा जो वर्तमान जोटा बाहरिला माने प्रिंट आउट पढ़िकिनी बाहर करागला सेथेर आउ से जो पुराना एफिडेविटा नहीं अर्थात 29 तारीख रा एफिडेविट नहीं अच्छा दी से जोटा एग्जिबिट जो पूराटा मार्क ହେଇଛି कोन
एग्जिबिट DU माइनर
exhibit DU which was downloaded today in court as per the order of the court passed in IA number so and so of 2023 doesn't show
does not contain
does not contain the affidavit in form 26 dated 29/3/2019 bracket exhibit से exhibit क्या कहते हैं
my lord 29/3 ହେଲା exhibit DP by 1 ହେଇଥିଲା
first affidavit ଟା जोड़ा
ଦେଖି ଦଉ
हाँ तेरा
exhibit
DP by 1 hello though
and it only contains
and अच्छा ठीक है and it only contains the revised affidavit in form 26 dated 30/3/2019 bracket exhibit
कर दंतु दीटा को my lord कर दंतु
दीटा
exhibit DP by 3
नहीं नहीं तीरी ऐसे revised affidavit
original available in the nomination paper
हाँ
exhibit DP by 3
आगे जोटा कौन तो जोटा अपनो
डाउनलोड कर
हाँ डाउनलोड करे सेटा एटा चलती ना
exhibit
सेटा
DU by 4
हाँ सेटा कौन तो DU by 4 हला
which is the downloaded copy of exhibit
which is the downloaded copy of तापरे original document
exhibit DP by 3
exhibit DP by 3 हला
आपण जेतले अपलोड करले 29 तारिख ता एवं परे अपलोड करले 4 तारिख ता 29 तारिख काहे डिस्प्ले हला नै लाइक रेस्पोंडेंट
फर्स्ट डे ऑफ अपलोडिंग दा सेठी से कॉन्फ़िगर करछि फर्स्ट डे ऑफ अपलोड रहउछि नॉमिनेशन पेपर भी रहउछि असंग एफिडेविट
एवं एटा ओवरराइड करछि
ठीक है तो क्वेश्चन फॉर्म में पहुंचाने is what is your question ask him
when
put the question
you uploaded exhibit DP by 3 in the portal of Election Commission of India on 4/4/2019, comma, the earlier affidavit, this overrided.
No, this
overrided the earlier affidavit.
No, question टा अपन पहुंचा ठीक है तो question
this overrided the earlier affidavit.
ନାଇଁ ନାଇଁ when you upload whether ଲେଖନ୍ତୁ whether ଏଠି whether ଦିଅନ୍ତୁ this ପୂର୍ବରୁ ଗୋଟେ ଲେଖ ଆରେ ସେଇଟା ଥାଉ ହଁ ସେଇଠି ଗୋଟେ ଲେଖନ୍ତୁ whether ଛୋଟ କରନ୍ତୁ whether this
latter affidavit
this latter affidavit overrided the earlier affidavit that is kete seta exhibit
DP by 1 in the portal of Election Commission of India.
Question mark when you uploaded exhibit DP by 3 in the web portal of the Election Commission of India on 4/4/2019, whether this latter affidavit overrided the earlier affidavit that is exhibit DP by 1 in the web portal of Election Commission of India? That is the question.
It is a system generator configuration.
Yes, I will. Yes. Since it is a system based configuration, comma, it happened so. It happened so. Happened, HAPPENED. Sir, date of uploading gala par 4 तारीख रे
देखंतु 4 तारिख रे अपलोड करथिले मध्य
जो दिन 4 तारिख रे पछरे करथिले भी से फास्ट डेट ता देखैबो
तो करूछु 29 मार्च।
अच्छा सेहिति पई ए जोटा आपण ए जो एटा देखौची 29 मार्च सेटा देखो से लेटर डेट ता देखुनी या कुछ
लेटर डेट ता देखैबो
so and that is the reason like that. Since it happened comma and stop kar diyantu, it happened so that is the reason why in the এটা হচ্ছে front page না in the first page
cover page of
mark করছিলে পরে
first page or cover page
আচ্ছা in the cover page of exhibit DU comma it was mentioned only the affidavit uploaded date, only the appeal, date of appeal, date of
affidavit uploaded in
first date of upload.
Only the date of
affidavit uploaded.
Only the date of affidavit uploaded is shown to be 29th March 2019 and not 4th April 2019. या तो कुछ
कारण सबबेले फर्स्ट डेट ऑफ अपलोडिंग ता शो करिवो.
This is the reason why in the cover page of exhibit due only the date of affidavit uploaded is shown.
Affidavit uploaded first time.
अच्छा
first date of uploading of affidavit.
अच्छा that is the reason why in the cover page of exhibit DU कौन लिखियो कौन दो?
Only the first date of.
Only the first date. First date of affidavit uploaded. The first date of uploading of the affidavit. First date of uploading the affidavit. Uploading the affidavit is shown to be 29th March 2019 and not 4th March 2019. Clear? It on your.
Apro ପଚାରିବି ତ
ଏଇଟା ସରିଗଲା ଏଇ chapter.
ଏଇଟା ବୋଧେ 58 ହବ. A3 ଏଟା ଦେଖାନ୍ତୁ A1.
section 33A काढून RPR 1950
ହେଲା 33A within bracket 1 subsection 1 ପାଇଲେ
33 capital A
subsection 1 को गले
heading होची right to information.
आज्ञा आज्ञा it has been prescribed that a
पाइले तो
सर ते पाइले सर
ठीक है बाहर करी दियंदा
33A again
it has been prescribed that a candidate shall, apart from any information which he is required to furnish under this act or the rules made thereunder in his nomination paper delivered under subsection 1 of section 33, also furnish information as to whether 1. He is accused of any offence punishable with imprisonment for 2 years or more in a pending case in which a charge has been framed by the court of competent jurisdiction.
yes
II. He has been convicted of an offence other than any offence referred to in subsection 1 or subsection 2 or subsection 3 of section 8 and sentenced to imprisonment for 1 year or more. Subsection 2 of section 33A of the RP Act 1951 prescribes सर आगे 1 ता चल जाओ
नहीं सर कौन पचान देटा तो सेक्शन टा अपन पढ़ी
कौन पढ़ सकता
हाँ करो
Subsection 2 of section 33A of the RP Act 1951 prescribes that the candidate or his proposer, as the case may be, shall at the time of delivering to the returning officer the nomination paper under subsection 1 of section 33 also deliver to him an affidavit shown by the candidate in a prescribed form verifying the information specified in subsection 1. से नॉमिनेशन दबा सहित गोटे प्रेस्क्राइब्ड फॉर्म रे थिबा एफिडेविट मध्य कैंडिडेट बा प्रपोजर कैंडिडेट शेयर करिवे ता प्रपोजर दाखल बा कैंडिडेट बा प्रपोजर दाखल करिवे Subsection 3 of section 33 of the RP Act prescribes that the returning officer shall, as soon as may after furnishing the information to him under subsection 1, display the aforesaid information by affixing a copy of the affidavit delivered under subsection 2 at a conspicuous place at his office for the information of the electors relating to a constituency for which the nomination paper is delivered.
ठीक है सर इरा प्रोविजन पढ़ी दिल व्हाट इज योर क्वेश्चन
मोर क्वेश्चन होती Rule 4A of the Conduct of Election Rules 1961 prescribes the candidate or his proposer, as the case may be, shall at the time of delivering to the RO the nomination paper under subsection 1 of section 33 of the Act also deliver to him an affidavit sworn by the candidate before a magistrate of the first class or a notary in form 26.
yes
मोर आपनको प्रोविजन ऑफ लॉ रिक्वायरमेंट ऑफ लॉ मोर आपनकर प्रश्न होची जेते बेले रेस्पोंडेंट आपनक पाखरे नॉमिनेशन फॉर्म दाखल कले ता सहित फॉर्म 26 रो एफिडेविट दाखल करिथिले ना नाही
when the respondent
on the first date of submission of his nomination
on 2/4/2019 submitted his 4 sets of nomination papers in form 26 he sir कौन दाखल करते कौन ता सहित
affidavit in form 26.
अच्छा nomination paper in form सेटा 2B ना sir
Nomination form 2B
a nomination paper
in form 2B
in a nomination paper in form 2B कौन
four sets of nomination.
Four अच्छी sir अच्छी 4 sets of nomination papers in form 2B along with
along with the same he also filed an affidavit in form 26 duly sworn in.
अच्छा sworn so form 2B पर comma दे दियो
affidavit
comma
sworn होगा
he along with the same also submitted affidavits in form 26
exhibit number दे दो
मैं अच्छी था जनरल क्वेश्चन
submitted affidavits in form 26 dated 2/4/2000
dated 2/4/2000
Clause 5.16 under Clause 5 nomination of HBRO Exhibit 38 deals with बाहर करूँ
Clause 5.16
Chapter 5 nomination HBRO पेज देखी दियंतु 83 देखले deals with affidavit in form 26 to be submitted by the candidate. ठीक तो 5.16.2 of HBRO, the notarized affidavit has to be filed latest by 3 p.m. on the last date of filing nomination.
yes what they do
big sir
File the 5.16.4 in the instant case pursuant to instruction contained under clause 5.16.4 page 83 of HBRO, you being the returning officer gave a notice to the respondent to submit a fresh affidavit complete in all respect in the checklist marked as Exhibit 39 by 2, Exhibit BL, Exhibit 40 by 2, Exhibit CD, Exhibit 41 by 2, Exhibit CU, Exhibit 42 by 2, and Exhibit DL.
After verifying the nomination papers and the affidavits on two
preliminary examination
अच्छा after preliminary exam verifying टा काटी दियो after preliminary examination of the nomination papers and affidavits filed by the respondent अच्छा after preliminary of such no it got such word करले चले सो link है जो such nomination papers and the affidavits filed by the respondent in view of the in view of clause 5.16.4 of exhibit eta कितने मार्क कीजिए of exhibit 38
page
83
bracket लिखूं तो page 83 comma as returning officer I gave notice to the respondent to submit a fresh affidavit complete in all respect on 2/4/2019 itself by checklists marked as
Exhibit 39 by 2
bracket रखी दियंतु BL सेही गोटाक
BL आगे से did
39 by 2 bracket लिखंतु BL
Exhibit 40 by 2 bracket CD
ଟିକେ ରୁହନ୍ତୁ କମା ଦିଅନ୍ତୁ exhibit 40/2 ब्रैकेट रे
CD
सेटा भी एग्जिबिट तो होची और कोन एग्जिबिट CD तापरे
exhibit 41/2
ब्रैकेट रे CU
exhibit
42/2
and
कर दियो लास्ट आइटम
again
and exhibit 42/2
exhibit DL and DL तो खाली है
हाँ
देखो accordingly the respondent submitted his fresh and revised affidavit in form 26, that is exhibit 43, 44, 45 and 46, and you granted receipt to that effect in checklist under exhibit 47 within bracket BP.
The respondent submitted the revised affidavits dated से revised affidavits गुड़ा dated थिला 3 तारीख अच्छा revised affidavits dated 3/4/2019 ताकु देला केबे 4 तारीख दिन on 4/4/2019
well within time
which were within time which were within time and already marked which are written and the revised affidavits have already been marked as exhibit 43, 44, exhibit 45 and exhibit 46 exhibits एस्टा काटी दियो जो 43 पूर्व जो एस्टा देइतले हला and accordingly I issued checklist dated 4/4/2019 to the respondent, which has already been marked as exhibit 47
within bracket BP.
Bracket रे BP. अच्छा BP.
Pursuant to instructions contained in clause 5.16.5 of HBRO exhibit 38 page 84, you being the returning officer gave a written reminder to the respondent in format C-3, which has already been marked as exhibit A, directing the respondent to publish information about his criminal cases in newspapers having wide circulation in the constituency area and on TV channel on at least 3 occasions each during the period from the day following the last date for withdrawal of candidature and 2 days before the date of poll. ଆପଣ C-3 जो फॉर्मेट अच्छी एग्जिबिट ए
required to submit information in newspaper having wide circulation in the constituency
again
and on TV channels on at least 3 occasions. Yes, I have given this.
केबे देइतले which is that is dated 2/4 जो न प्रथमे देले सेहि दिन देइतले on 2/4/2019 I issued exhibit केते कोन exhibit A to the respondent instructing him to publish a declaration of the criminal cases pending against him for wide publicity, in newspapers with wide circulation in the constituency area, comma, at least on 3 different dates
occasions লেখা है
अच्छा
occasions main
on 3 different occasions अच्छा ठीक है सर हैला तापरे से कॉलेज की नहीं
It during the period
newspapers
and
as well
TV.
as well as on TV channels সেটা এরিয়া পরে
সেটা লেখা আছে টিভি চ্যানেল আচ্ছা লিখে দিন তাহলে অ্যাড করে দিন
এরিয়া পরে কনস্টিটিউয়েন্সি এরিয়া পরে
constituency area
পরে
out asantu
as well as on TV channels at least on 3 different occasions each କୋଉ ଦିନରୁ କୋଉ ଦିନ କାଢିବେ ଦେଖନ୍ତୁ ଫାର୍ଷ୍ଟ ପାରାଗ୍ରାଫରେ ଲେଖା ହେଇଛି ଆପଣଙ୍କର ଫାର୍ଷ୍ଟ ପାରାଗ୍ରାଫ ଗୋଟା ଏକ୍ଜିବିଟ୍ ହେଇ ଆପଣଙ୍କୁ ନୋଟିସ୍ ଦେଇଛନ୍ତି
କେବେଠୁ କେବେ ଭିତରେ ଆକୁ କାଢିବେ
during the period from the day following the last date for withdrawal of candidate.
acha during the dates during the dates from the day following the last date for withdrawal of candidature and up to 2 days before the date of poll या तो ठीक है ये जहाँ language है मुझे
ଦେଖନ୍ତୁ ଆପଣଙ୍କ ହାତରେ ଧରିଛନ୍ତି ଏକ୍ଜିବିଟ୍ 38 HBR ପେଜ 476 କି ଯାଆନ୍ତୁ
नहीं ଏଇଟା ଯୋଉ ଆପଣ ଦେଲେ ସେଇଟା ଆପଣ କିଛି ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି ସିଏ ଏ ଯୋଉ ନ୍ୟୁଜ ପେପର ରେ ପବ୍ଲିଶ କଲା ପରେ ଆସି ଆଣିକି ଆପଣଙ୍କୁ ସବମିଟ କରିବ ଦେयर ଇଜ नो ସଚ୍
ଆମକୁ ନାହିଁ ଡିଷ୍ଟ୍ରିକ୍ଟ ଇଲେକ୍ସନ ପାଖରେ ଦବା ପାଇଁ ପ୍ରୋଭିଜନ
ସେଥିରେ ଅଛି
ଆଚ୍ଛା ଆପଣଙ୍କୁ ଦବାର କିଛି ନାହିଁ ଏଠୁ ଗୋଟେ କୋଶ୍ଚିନ୍ ଇଏ କରିଦେବେ ଟୁ କୋଡ୍ ଖାଲି ଗୋଟେ କରିଦିଅନ୍ତୁ ଯେଟା କ୍ଲାରିଫିକେସନ ହେଇଯିବ ଟୁ କୋଡ୍ whether क्वेश्चन मार्क क्यू कर दिया whether after से जो लैंग्वेज टाइम whether after publishing ना कौन से जो after publishing in the newspaper with so and so और नहीं असुन तक कटा था कटू whether after publishing in the newspapers whether after publishing in the newspapers with wide circulation in the constituency area सेटा काटी दियंतु सेटा टीवी चैनल दरकार कमा सेट लिखूं तो गोटी गोटी कर दा the respondent submitted the proof of the same before you question mark that enter कर दी तोड़ू नहीं आसान answer it is not required अपन को जनी एटा अपन पाखर submit it is not required to be submitted before me as returning officer but eta code submit but it is to be submitted
district election officer along with their
before the district election officer out kono
along with their account of election expenses
along with their kundu
election expenses account of election expenses
account of
election expenses
election expenses अच्छा आउ गोटे ताजर रखु जे टिके तळु खसंदी लिखा है at least 3 occasions one so dates अच्छा सेमती जो आपण कहले जो टीवी चैनल्स कथा को टीवी चैनल्स रे को दिन सेटा बाहरिला अर्थात समस्त अवगति ये करागला तार डिटेल्स मध्य से आपण को दबार किछि प्रोविजन अछि से गुडा क्वेश्चन लिख दियन वेदर से फर्स्ट क्वेश्चन दा कॉपी कर दन whether after broadcasting of after telecasting, after telecasting of
on TV channels. On TV channels.
on TV channel, on TV channels. Say you regarding criminal cases, regarding criminal cases, comma, the respondent submitted proof of the same before you question mark on এটা আপনার পাখে it is not required to না সেটা লিখে it is not required সেটা কপি করে নিয়ে আসুন it is not কে সেটা তাଙ୍କ পাখে দেবার কিছু আছে কি না নাই
খালি নিউজ পেপার লেখা আছে
আচ্ছা ঠিক আছে it is not required to be stop ଆପଣ କହିପାରିବେନି ସେମିତି କିଛି provision ନା ନାଇଁ ନାହିଁ आप କହିପାରିବେନି I cannot say whether there is any provision to submit proof of the same before the district election officer. Stop. ठीक है सर पहुंचाऊं
देखो
फर्स्ट सेंटेंस लिखले फर्स्ट क्वेश्चन जोटा कले
हाँ
एटा जोटा रहिला क्रिमिनल केसेस
अच्छा whether after publishing
regarding criminal
अच्छा सर ऊपर लिखूं आप whether after publishing after publishing the details of the criminal cases the details of the criminal cases
by the respondent
in the newspapers with reference code in the newspaper right the respondent submitted the proof of the same before you. It is not required to be submitted before me as returning officer, but it is to be submitted before the district election officer along with account of their along with their along with his account of election expenses. Next question whether after telecasting on TV channels regarding the criminal cases, the respondent submitted the proof of the same before you. It is not required to be submitted before me as returning officer. I cannot say whether there is any provision to submit the proof of the same before the district election officer. Sir.
नहीं आगे पेज 476 टा देखिले से जो फॉर्मेट ऑफ C-3 टा देजी जेम कोथरे अपन लिखिकरी तांको देबे to publish in newspaper and
ଆମେ ତ ଦଉଛୁ C3
C-3 ଅଛି ତ हाँ 476 In compliance to your above instruction under Exhibit A, the respondent published in format C-1 that is declaration about criminal cases on 3 occasions in Delhi Odia newspaper Matrubhasha and Prajatantra.
সেটা কিন্তু সে জানিবে তারপর সাবমিট ই নথিলা মার্ক হি ইজ আচ্ছা from नहीं ताले इमेज कर देवे from a exhibit to it appears
आगे आगे
अच्छा
from exhibit
सर्टी देखे ही दूंगा आगे देखे ही दूंगा से जो এইটা তো আপনি ইস্যু করে দিলেন না এই ডকুমেন্ট ଦେଖିକିନି କୁହନ୍ତୁ এই ଯୋଉ ନ୍ୟୁଜ ପେପର ଗୁଡାକ
କଲେ ଫର୍ମାଟ C1 ରେ କାଢିବା ପାଇଁ ଫର୍ମାଟ C1 ରେ କାଢିବା ପାଇଁ ସେ ଲେଖିଲେ ଫର୍ମାଟ C1 ଡିକ୍ଲାରେସନ अबाउट କ୍ରିମିନାଲ କେସେସ୍ ଏଇଟା ମାତୃଭାଷା ଏଠି ସେ କାଢିଲେ ଫର୍ମାଟ C1
ଆଜ୍ଞା
ଏଇଟା ହେଲା ମାତୃଭାଷା ସେ କାଢିଲେ ଫର୍ମାଟ C1 ରେ ଏଇଟା ପ୍ରଜାତନ୍ତ୍ର ସେ କାଢିଲେ ଫର୍ମାଟ C1 ରେ all the 3 occasions which has been marked as exhibit
ତିନି ଥର କାଢିବାକୁ ଅଛି ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଇଥିଲେ ଏବଂ ଏଇଥିରୁ ଜଣା ପଡୁଛି ସେ କାଢିଛନ୍ତି ଓକେ ଏବଂ ଯୋଉ ପିରିୟଡ ଭିତରେ କାଢିବା କଥା ସେଇଟା କାଢିଛନ୍ତି ଡେଟ୍ ଦେଖିନି କୁହନ୍ତୁ ଠିକ ଅଛି ଆଚ୍ଛା as per the instruction given to the respondent সেটা ভাইড এক্সিবিট সেটা ক্ষেত্রে আপন যে ইনস্ট্রাকশন ভাইড এক্সিবিট এ না A/1
नहीं
A by A खाली रहेगा A/1 में comma he published the details of criminal cases pending against him in
Format C1.
in format C1. Format C1 in C-1 अच्छा in कोते से exhibit उड़ा ना
in matru in exhibit B
सड़ा
B/1
हाँ
by B/1 respective portion टा B/1 ଅଛି କେବଳ ରଖିବା B/1 exhibit C/1 and exhibit D/1 जो पकड़ले जे इटा well within time से publish करते
which on very stop it stop कर दियो on verification of exhibit B/1 C/1 and D/1 I find comma कर दियो I find that the respondent has published it within time as stipulated under exhibit A. ठीक तो?
yeah in format C dash
ठीक है
दरकार ना फॉर्मेट सी डैश 1 टा अछि ना
पेपर
डॉक्यूमेंट रे
डॉक्यूमेंट अछि
फॉर्म तापरे रेस्पोंडेंट in exhibit 43, 44, 45 and 46 under its item number 5II has declared that as many as 13 numbers of criminal cases are pending against him.
original one टा आपण देखु paragraph item number 5 को जानतु एटा नुहे एटा आपण रिजेक्ट करले माने मागिले ताको आगुटे रिवाइज कर तो रिवाइज्ड एफिडेविट एटा रिवाइज्ड एफिडेविट 3-4 रो item 5 को जानते 588 को item 5 is available at its internal page 3
revised affidavit dated 3/4/2019
okay
marked as exhibit 43 44 45 46
okay
को पेज सर
under item 5II
अच्छा item 5II हाँ
at internal page 5 to 3 sorry my lord 3 4 5
last page टा करे नंबर
6 आगे पहुंच 7 and 8 तापर 6 नंबर आइटम आरंभ होला
से जो 3 to 8 पेज भितरे कौन पचारले क्वेश्चन टा सर
पचारती जे सेटा अछि माने 13टा क्रिमिनल केस मेंशन
सेगुडा को आपण जो पाखे आनी किनी रेस्पोंडेंट आनी दाखल कले ये जो रिवाइज्ड एफिडेविट 3 तारीख दिन रो एफिडेविट 4 तारीख दिन दाखल कले तारो ये जो पेज सर कहउछंदी 3 रु 8 आइटम नंबर 5 रोमान 2 रे हैना ता नारे जेतेक क्रिमिनल केस व्हिच इज 13 इन नंबर से पेंडिंग अछि बेली से दर्शई थिला 13टा कोडी गणाई 1 2 3 4 नंबर दी
I2 XII
अच्छा
ए रे गला बी रे देखंतु I2 ता डिटेल्स ता देला I2 XII 13
एटा कोन अलग
एटा होची माने हेडिंग देखंतु एटा एफआईआर नंबर एठी दबार अछि और नेम ऑफ द पुलिस स्टेशन दबार अछि
आगे
एटी केस नंबर विथ नेम ऑफ द कोर्ट दबार अछि ए जो 13टा रो डिटेल्स ए 13टा रे देला देखंतु
एते डिटेल कहया दरकार नै खाली आपन देइथिला ऑलराइट व्हेन द respondent submitted his revised affidavits dated 3/4/2019 on 4/4/2019 by exhibit 43 44 45 and 46 he mentioned pendency of 13 criminal cases, as many as 13 criminal cases against him in under item number 5 Roman 2 in pages 3 TO 8.
43, 44, 45, 46.
Of sure.
Kindly compare the 13 criminal cases mentioned in Exhibit 43, 44, 45, and 46 with that of Exhibit B1, B by 1, C by 1, and D by 1.
जो न्यूज़पेपर
न्यूज़पेपर ये तीनटा भी ऐसे सही तरहटा भी न्यूज़पेपर
रैंडमली चेक कर दियंतु तांकु से पेज टा के दियंतु न्यूज़पेपर देखि देई जे गोटे केस धरंतु ताकू सेथरे छपेइचंदी कि नाही आ ए जो तीनटा पेपर रे से पर्टिकुलर केस नंबर टा जोटा को से तांगा एफिडेविट रे मेंशन करचंदी सेटा अछि ना नाही देखि दंतु दी तीनटा केस रो एमती वेरीफाई कर दो टोटल तो 13 टा कोन
आगे
their case is not that you have not printed it correctly. Their case is that some number has been incorrect. That is thing. Police station.
से कोठी जिल्लाटा माने खोर्धा जगह रे कटक
असिस्ट करने से तो जणा पड़ने सर से सब
देखंतु
आपण एटा देखंतु
ताम गोटे देइले कोन
एटा देखंतु
गोटे केस नंबर दियो
पढंतु
प्रथमटा धरंतु
आपण पढंतु मोटी आंगुल देखंतु 22/18 2018 अछि आज्ञा आपण टिक मारंतु एटा कोर्ट
केस नंबर अछि तो केस नंबर अछि तो
हां केस नंबर
हां जीआर केस अछि सेही जीआर केस नंबर पढिछि तो
23/2018
पेपर रे देखन से जीआर केस लिखा छै
आपण देखौछि आपण टीआर नंबर 41 प 2013
गोटी गोटी देखन ततर होंतुनी से देखन
तापर देखंतु कोंतु आपण 1137/12 जीआर केस ए देखंतु आज्ञा तापर देखंतु 2020 ठीक अछि 2020/2012 एके साथ एटा हां तापर देखंतु 85/12 ठीक अछि देखंतु हम देखै एटा 85 पर 84 84 पर 83 83 पर 680/2012 आज्ञा तापर देखंतु 15 2011 आज्ञा तापर हां वीजीआर नंबर वीजीआर एट लिखाई छी एटी जीआर केस नंबर 1168/2011 एंड जीआर केस नंबर 1568/2010 एंड टीआर नंबर 1 एस फाइल 2009
सो हां देखि नहीं देखांत let him be satisfied से जिनसटा देखिंतु आपण देखि दउ same news item or same information is to be published thrice upon
yes my lord it has been said
same all right after verifying lekon after verifying the details of criminal cases mentioned in से जो पेजेस नंबर 3 to 8 सेटा नेस कॉपी करी पेस्ट में
एग्जिबिट 8 टू नेस
8 नेस तो up to 46 जाइन and also
with that of
after verifying so and so with that of exhibit B by 1 comma C by 1 and D by 1 exhibit D by 1 and order 1 and exhibit D by 1 comma I find that the respondent has correctly shown or soon correctly published the details of pendency of criminal cases in the newspapers. Sir.
Do you have any proof with you that the respondent published on 3 occasions in the TV channel about his criminal pendency of criminal cases?
No, I have no proof.
Was there any complaint by anybody before you, including the election petitioner or his proposer or his agent or his supporter or anybody on his behalf, that the respondent has not published it thrice on TV channel?
Nobody, nothing, no complaint. Acha, kintu, acha, all right. I have, I got no proof of telecasting of the details of criminal cases pending against the respondent on 3 occasions, as was directed in Exhibit Exhibit A. I got no proof of some, but nobody, including the election petitioner or his
or anybody on his behalf,
or anybody on his behalf, ଆପଣ पर କେହି complain କରିନଥିଲେ, complaint before me on his behalf, complaint before me regarding non-telecasting of the details of criminal cases of the respondent. Violating my instruction set out under in Exhibit A.
Next paragraph. 59 hobo. 58. Chapter 6, scrutiny in HBRO, Exhibit 38.
Page.
Those.
My Lord, 98. 98.
This chapter deals with provisions and procedure for scrutiny of nominations. You, being the returning officer, personally conducted the scrutiny of all nomination papers filed by the respective candidates.
Yes.
Clause 6.2.
ଯାଇଛି ଆଗରୁ ଯାଇଛି ମୁଁ କରୁଥିଲି ମତେ ଗୋଟେ team of officers assist କରୁଥିଲେ already ଯାଇଛି.
Clause 6.2.1 of chapter 6 of HBRO prescribes as follows. 6.2.1 को जानतु ମୁଁ ଖାଲି ଆପଣଙ୍କୁ ଦେଖେଇ ଦଉଛି ଆପଣ ତାପରେ ହଜୁରଙ୍କୁ ଯା କହିବେ.
6.2.1 ପାଇଲେ ତ that is scrutiny a judicial quasi judicial duty will ଲେଖା ହେଇଛି.
ଆଜ୍ଞା ଆଜ୍ଞା
ପଢନ୍ତୁ sir ପଚାରନ୍ତୁ.
Scrutiny of nomination paper is an important quasi judicial function.
Yes.
2. This duty has to be discharged with complete judicial detachment and in accordance with the highest judicial standard. Returning officer must not allow any personal or political predilections to interfere with the procedure that he or she follows or the decision he or she takes in any case. Returning officer should be fair, impartial, and treat all candidates equally. The returning officer must conduct him or herself in such a manner that it would appear to all concerned that he or she is following this high code of conduct. Returning officer, even if a candidate or his agent is difficult or cantankerous, the returning officer must be courteous and patient but firm. Returning officer is expected to be prompt and orderly. Returning officer should not take any direction from any superior authority, including the chief electoral officer or the commission's observer, including in deciding the validity or otherwise of a nomination paper. Returning officer should only be guided by the provisions of law and instructions given by the commission from time to time. Yes. You meticulously maintained and followed all these instructions. Yes.
I am aware that responsibilities as a returning officer as for the provision mentioned under clause 6.2.1 under the chapter scrutiny, under the chapter bracket 6 comma scrutiny को 6 कर दियो chapter 6 scrutiny bracket लिख दियो page 98 in exhibit 38, and accordingly I meticulously followed the same. Stop. So
kindly look at subsection 1 of section 36 RPR. 36, 36.1, subsection 1 of 36. Read with instructions under clause 6.3.1 of HBRO, exhibit 38 at page 98. On the date fixed for scrutiny of nominations, the candidate, their election agent, one person of each candidate, and one other person duly authorized in writing by each candidate. Such person can be an advocate also if the candidate so desires, and no other person shall be admitted to the scrutiny. Yes. You also meticulously followed this instruction in the HBR.
okay, same Kondo. I am aware about the provision. I am aware about the provision mentioned. I am aware about the provisions mentioned in clause 6.3.1 regarding persons to be admitted at the scrutiny under chapter 6.1 subsection, and accordingly I meticulously followed them.
As well as subsection 1 of section 36.
अच्छा, as well as कर देंगे वो same जिनिस सेट कर as well as सेट कर दो 98 पर exhibit 38 पर as well as as well as section 36 bracket 1 of 1 नहीं इम्तिया 1 से जो 1 of RP Act 1951 of टा कर दियो as well as section 30 so Accordingly, I meticulously followed the same. Okay.
As specified in your notice in Form 1, that is Exhibit AF, you conducted scrutiny of all nomination papers of all the candidates at the office of Sub-Collector Kotak Sadar from 11 a.m. onwards on 5/4/2019.
সেটা কোথায় জানা
Exhibit AF.
Exhibit AF.
Pursuant to Exhibit AF.
अच्छा pursuant to
Okay.
pursuant to Exhibit AF. Hala, comma, I conducted scrutiny of all the nomination papers of all the candidates who filed who filed of all the candidates on date on kebe kale 5 tarikh bra
5/4.
on 5/4/2019 in between
11 onwards.
acha which on so and so which commenced from 11 a.m. I conducted এবং I conducted so and so এবং ଆପଣ ସେଠି କହିଥିଲେ ଯେ ଆପଣ ଗୋଟେ team of officers ଆପଣଙ୍କୁ ସାହାଯ୍ୟ କରିବେ with the assistance of a team of officials. ঠিক আছে
ଦେଖନ୍ତୁ come to clause 6.4 of HBRO Exhibit 38 page 99. This further prescribes that if any candidate, his election agent, his proposer, or the person authorized by him desires to examine any nomination papers or the accompanying document, as returning officer, you shall give them all reasonable opportunity for examining the same with respect to all candidates. Yes, you also meticulously followed this procedure.
I also meticulously followed the provision of on a provision under clause 6.4.1. See, under chapter 6.
Page 99.
Basically, page ta change.
Exhibit 38.
नहीं गोटे पेज अंडर खाली पेज टा चेंज हो सेटा सेगुडा रहइबो
आगे
खाली से पेज टा चेंज हो 99
एग्जिबिट 38 टा रहइबो
हां सेटा रहइबो खाली पेज टा रहइबो 99
section 36 subsection 1 of the RTI
and visualize seटा I also so meticulously followed regarding giving opportunity regarding giving reasonable facilities acha and gave reasonable facilities to the for examining the nomination papers
of all candidates
of nomination papers or the and nomination papers and the accompanying documents of all the
candidates
of all by all present
accompanying documents and all the candidates by all
present
by all present
at the time of scrutiny of
देखंतु as returning officer you are required to inform to all present whether all candidates have furnished the requisite information in the prescribed pro forma duly supported by affidavit in form 26 आपण जणैबा कथा
6.4.1 अछि
आगे
सेटा तो फॉलोड करजी आउ एटी लिखि दियंतु and intimated कर दंतु and I also said and I also informed to all present
Kindly come to page.
Whether to verify whether all to examine whether all candidates furnished the requisite information in the prescribed forma duly supported by affidavit. Sir.
Kindly come to page 99 and 100, HBRO, Exhibit 38. Clause 6.7 of Chapter 6. Under there is a heading, presumption of validity is prescribed as follows. 1. There is a presumption that every nomination paper is valid, unless the contrary is prima facie obvious or has been made out. 2. In case of a doubt as to validity of a nomination papers, the benefit of such doubt must go to the candidate concerned and the nomination paper should be held to be valid. 3. Remember that whenever a candidate's nomination paper is rejected without proper reason, that can be a reason to set aside the election in an election petition. Returning officer should adopt a comparatively liberal approach in dealing with minor technical or clerical errors. Subsection 4 of Section 34 mandates that nomination papers shall not be rejected on a ground or defect which is not substantial. While scrutiny of a nomination paper, you scrutinize each and every nomination paper, keeping in view all these instructions contained in the above paragraph of Exhibit 38.
Yes,
I am conscious about the presumption of validity of every nomination paper. As mentioned under clause 6.7.1 under chapter 6 chapter 6 scrutiny page 9900 পর্যন্ত 9900 পর্যন্ত 99 ঠিক আছে of exhibit 38 and accordingly I duly verified all the nomination papers filed by the respective candidates at the time of scrutiny. Sir.
Including the
ଦେଖନ୍ତୁ, kindly come to subsection 2 of section 36 of RP Act 1951.
Okay.
On the date fixed for scrutiny of nominations, you shall have to examine as to whether the candidate either is not qualified or is disqualified for being chosen to fill the seat under any of the following provisions that may be applicable. कौन ସେଇଟା? ସେଟା ପୁରା ଗଲାଣି ଆଗରେ ଅବଜେକ୍ସନ ପାଇଁ ଦିଆ ହେଇଥିଲା ଶୁଣୁନାହାନ୍ତି କି? ଆଚ୍ଛା ନାଇଁ ଅବଜେକ୍ସନ ସ୍କ୍ରୁଟିନି ଦିନ ଆପଣ ଉପସ୍ଥିତ କ୍ୟାଣ୍ଡିଡେଟ୍ ବା ତାଙ୍କ ରିପ୍ରେଜେଣ୍ଟେଟିଭ ମାନଙ୍କୁ ଅବଜେକ୍ସନ କରିବା ପାଇଁ ସୁଯୋଗ ଦେଇଥିଲେ ତ ଟୁ ଏକ୍ସାମିନ ଦି ନମିନେସନ୍ସ ଆଣ୍ଡ गिव देयर ऑब्जेक्शंस
if any.
if any.
Acha. I gave opportunity to all the persons present at the time of scrutiny to examine the nomination papers of ଯେକୌଣସି କ୍ୟାଣ୍ଡିଡେଟ୍ କର ଚାହିଁବେ ସେମାନେ ଦେଖିପାରିବେ of any candidate they like of any candidate they like and raise objection comma if any
ଅବଜେକ୍ସନ କିଛି ଆସିଥିଲା କି କେହି ଉଠେଇଥିଲା କି କୌଣସି ନମିନେସନ ସମ୍ପର୍କରେ?
I gave opportunity to all the persons present at the time of scrutiny to examine the nomination paper of any candidate they like. Any candidates they like and raise objection if any. हाँ सानकर क्वेश्चन होची ये जो opportunity देले आपण अवश्य आगुरु कहिसेंती कोनोसी किए अच्छा
रेस्पोंडेंट को नॉमिनेशन ऊपर भी कई ऑब्जेक्शन उठे
in spite of giving such opportunity no one raised any objection to the nomination papers filed by the respondent in any manner.
On the date of scrutiny, did you examine as to whether the respondent is qualified under Article 84, 102, 173 and 191 or Part 2 of the RP Act 1951 either qualified or disqualified?
जोड़ा कही दी अपन करथिले on the date of scrutiny comma I also examine whether the respondent was qualified or
not disqualified
and qualified and not disqualified to contest the election, sir.
Okay.
To contest the election in question, to contest the election in question कहले चलिबो से सब कवर अप गया
ये आर्टिकल
अच्छा as per the provisions mentioned under articles sir 84 आउडा कोडा कहले
102
applicable मोए केस रे सेटा एमपी को पाई
अच्छा
173 and
191
अच्छा देखो articles 173 and
191
से 84 टा काटी 84 टा काटी
and Part 2 of
and any of the provisions
Constitution of India sir आउडा कोन कहउतले
Part 2 of
and Part 2
of RP Act 1951.
RP Act 1951. Stop. Yes.
You also examined that whether there has been a failure to comply with any of the provisions of Section 33 or Section 34. Clause B टा को देखो.
33
36B.
36B.
Again 2B.
36 2B. B. अच्छा, there has been अच्छा ठीक है हाँ.
Yes.
I also examine whether there has been a failure to comply with any of the provisions of section 33 or section 34
By the respondent.
or section 34 of the RP Act 1951 by the respondent.
And found
कौन
फाइले तांकर किछ फेलियर थिला कि?
And I found no failure. And I found no failure on the part of the respondent. Stop.
Did you examine that the signature of the candidate or the proposer, that is respondent and his proposers, on all the 4 sets of his nomination papers were genuine?
Yes, sir.
I also examined and came to and found that the signature of the respondent, signatures of the respondent and his proposers and his all in the on the nomination are to be are genuine. आज name ना ठीक है आज genuine. I also examined and found that the signature अच्छा ठीक है आज genuine हाँ ठीक है.
Achha. At the time of scrutiny, was there any objection on behalf of the election petitioner or on anybody on his behalf to the nomination of the respondent?
No.
जायजी सर
जायजी चल ठीक. Acha, you being the returning officer at the time of examining, scrutinizing all 4 sets of nomination papers of the respondent, became satisfied that the respondent is qualified and not disqualified under article Setagala.
Yes, sir.
The respondent is qualified and not disqualified on any of the proposed part 2 over Jaichi.
Yes, sir.
That the respondent has not failed to comply with
Jaichi
33 Gala.
Just Gala.
That the signature genuine se Gala. That there is no substantial defect in all
Yes,
4
sir.
sets of nomination.
Yes, sir.
For the above reasons, all the 4 sets of nominations.
36 strategy as per subsection 4 of section 36. I found that.
हाँ सर पचार दिन.
Kindly look to subsection 4 of section 36.
Again.
After examining all the regions and points as set out, you came to the conclusion that all the 4 sets of nomination papers of respondent are valid. And there is no substantial defect.
Yes.
As prescribed under subsection 4 of section 36.
After due verification and scrutiny of the 4 sets of nomination papers and the accompanying documents filed by the respondent, on 2/4/2019 and 4/4/2019, comma, I found that there was no defect of a substantial character in the same, जोथिपाई आपण accept कले, for which I accepted the same, accepted all the 4 sets of nomination paper
of the respondent.
गला पर respondent of the respondent गला. And
Kindly look to
as valid one, accepted as valid. हाँ.
kindly look to clause 6.9, chapter 6, HBRO, exhibit 38, page 100 and 101. दीटा जाक देखिए 6.9.1 to 6.9.6, page 100 to 101. एथरे दीटा जाक देछि insufficient ground for rejection of nomination papers and for rejection of nomination papers in detail. You have gone through these provisions as mentioned in the handbook of HBRO and meticulously followed.
Yes. I have gone through the provisions under clauses 6.9.1 TO2, 6.9.6 and 6.10 and clauses
provisions under
अच्छा under हाँ से जो डालने को ये जो under chapter से जो डालने चले ଗୋଟେ chapter ଆସୁନଥିଲା chapter 6 ନା କଣ ଗୋଟେ ଆଚ୍ଛା ହଉ ଠିକ ଅଛି ସେଟା ପରେ କରିଦବା 6.9 sir ठीक and clause 6.10.1
to 6.10.3
to 6.10.3 that is bracket
101 to 104
हाँ पेज होची 102 102 TO2 और 102 103 ହେଲା of exhibit 38 कोटा कहले
6.9.6 जो सरेगा
ସେଟା ପୁରା ରହିଲା ତ
ପୁରାଟା ରହିଗଲା ପରା
100 କଣ ଅଛି 6.9 ମାଇନର
6 हाँ हाँ 6.9 ସେଟା ଆରମ୍ଭ ହେଇଛି ସରିଛି ଏଠି ହଁ 6. I have gone through the provisions under so and so of exhibit 38 and I meticulously followed the provision while examining the nomination papers of the respondent as well as other candidates.
Sir, 6.10.1 to 6.10.3
गला परा सर 100 ରୁ 103 ଭିତରେ ସେଟା ରହିଗଲା
अच्छा all 4 sets of nomination papers
गला सर valid ବୋଲି
ठीक है अच्छा the election in question sir आ गोटे paragraph
କେତେ ପାରା ଯିବ
एटा बोधे 60 हो
sir
The election in question was conducted smoothly on 23/4/2019.
The election in question was conducted smoothly on केबे सर 23/4/2019 stop
The counting of votes was held on 23/5/2019.
Comma कर दियो, comma कर दियो. The counting of votes was held on,
23/5/2019.
sir,
And on the same day, you declare the result of election.
on the same day, I declare the result of the election.
ହେଲା form 20 ଟା ଦିଅନ୍ତୁ କଣ ମିଶି ହେଲା
The election in question was conducted smoothly on sworn, so the counting of votes was held on, and on the same day I declared the result of the election. कौन मिसी होला
ଠିକ ଅଛି
ସେ 23/5 ଡିକ୍ଲାର କଲେ ବୋଲି ରହିଲା
ରହିଛି ତ
अरे same day माने कौन? The election counting of the vote was held on sworn, so and on the same day माने 23/5 ଆଉ କଣ? ହଁ sir ପଚନ୍ତୁ.
ଦେଖନ୍ତୁ ସେଇ ଫର୍ମ 20 ଯୋଉଥିରେ ଆପଣ ରେଜଲ୍ଟ ଡିକ୍ଲେୟାର କଲେ କାଇଣ୍ଡଲି ଲୁକ୍ ଟୁ ଦ୍ୟାଟ୍ ଦିସ୍ ଇଜ ଅ ଷ୍ଟାଚ୍ୟୁଟୋରୀ ଫର୍ମ
That is marked as
X/10
exhibit. Objection ହେଇନି ତ?
ନା X/10 ହେଇଥିଲା
ଠିକ ଅଛି.
ଏକ୍ସିବିଟ୍ ହେଇନି ହବ
ଆଚ୍ଛା ହବ.
ଏବେ ହବ
ହଁ.
the same be marked as exhibit DU
DU
ଆଜ୍ଞା
ଏଇଟା ଗଲାଣି ପରା.
ଆଉ DV ତାହେଲେ ହବ
ହଁ ଏଇଟାକୁ ଆପଣ ଡିକ୍ଲାରେସନ କରିଥିଲେ ତ? ଆଚ୍ଛା exhibit I declared
earlier mark ହେଲା X/10
as I declared the result of the election.
Final result sheet. Final results.
The final result sheet is marked
In form
in form 20.
in form. The final result sheet in form 20 is the final result sheet in form 20 is marked as exhibit DV.
ହେଲା ନା ଠିକ ଅଛି
ଆଗଟା ଆগে ସେଠି ଅଛି ସେ ଚିହ୍ନଟା
ଆଜ୍ଞା
ଆଚ୍ଛା ବ୍ରାକେଟ ଲେଖନ୍ତୁ earlier marked as exhibit X/10
ଆଜ୍ଞା
ଖାଲି marked X/10 ହଁ stop ଦିଅନ୍ତୁ
ପାରାଗ୍ରାଫ ଗୁଡା ଦେଖାନ୍ତୁ ସଜେସନ ଦେଇକିରି କ୍ଲୋଜ କରିଦଉ
ଆଉ ଗୋଟେ ପାରାଗ୍ରାଫ କରିବେ
ଆଜ୍ଞା
61 ସାର୍ ପଚାନ୍ତୁ
kindly look to pleadings in paragraph 7A पेज टा केते देखले
ତାଙ୍କ ନାଁରେ ଯୋଉଟା ଅଛି ମାନେ ଯୋଉ illegally accepted
ଆଜ୍ଞା
ଆପଣଙ୍କ ନାଁରେ ଯୋଉ ଇଲେକ୍ସନ ପିଟିସନର ଯୋଉ ଅଭିଯୋଗ ଗୁଡା କରିଛି ସେଗୁଡାକ ସାର୍ ପଏଣ୍ଟ ଆଉଟ କରୁଛନ୍ତି ହେଲା ସେଗୁଡା ଦେଖିକିନା ଆନ୍ସର ଦିଅନ୍ତୁ କୋଉ ପେଜ ସାର୍ କୁହନ୍ତୁ ଇଲେକ୍ସନ ପିଟିସନ
पेज 7
7 କୁ ବାହାର କର
10th line from bottom
ଇଲେକ୍ସନ ପିଟିସନ ର ପେଜ 7 ଇଲେକ୍ସନ ପିଟିସନ ଟାକୁ ଆସନ୍ତୁ ଏତ ଲିଷ୍ଟ ଅଫ ଇଲେକ୍ସନ ପିଟିସନ ପ୍ରଥମରେ ଥିବ ନାଇଁ
ନାହିଁ ମୁଁ ମେଲର ଫଟୋକପି ଦେଖେଇଦେବି
ନାଇଁ ରୁହନ୍ତୁ ମୁଁ ଆଗେ ଦେଖେ ଇଲେକ୍ସନ ପିଟିସନ ଟାକୁ ବାହାର କର ଗୋଟେ ରଖିବା କଥା ଇଲେକ୍ସନ ପିଟିସନ ଯୋଉଠି କ୍ଲିକ କଲେ ସେଟା ଖୋଲିବ ଅସୁବିଧା ହବ ନହେଲେ ଇଲେକ୍ସନ ପିଟିସନ ଅମକ ଅବଜେକ୍ସନ ସବୁ ଷ୍ଟେପ ବାଇ ଷ୍ଟେପ ଯିବ
ଆମ ପାଖରେ କପି ନାହିଁ
ସେ ଯେ ହଜୁର କହିଲେ ଆମେ ସେଟା ଦବା କାରଣ ସେ ହଜୁର ଦେଖୁଛନ୍ତି ଅଲରେଡି ସ୍କାନ କପିଟାକୁ କିଛି ଯିବ ଆଉ କିଛି ଅବଜେକ୍ସନ
ନହେଲେ ଇଲେକ୍ସନ ପିଟିସନର କପିଟା ଦିଅନ୍ତୁ।
ହଁ ସେ ଗୋଟେ ଆମକୁ ଦେଇଥିଲେ।
ଇଲେକ୍ସନ ପିଟିସନ ଏଇଟା ପୁରା ଏଇଟା ହଉଛି ଅର୍ଡର ସିଟଟା ଗୋଟେ।
ସେଟା ନୁହଁ,
ଆରେ ଇଲେକ୍ସନ ପିଟିସନଟା କୁଆଡେ ହେଲା?
ସେଟା ଆପଣଙ୍କର ଡେସ୍କଟପରେ ରହୁଥିଲା।
କଣ ଏଇଟା?
ସେଟା ତ
ଟିକେ ରୁହନ୍ତୁ। କାଇଁ ଇଲେକ୍ସନ ପିଟିସନ କାଇଁ? ଏଟା ପୁରା ଇଏଟା। ଏଇଟା ହଉଛି ଇଲେକ୍ସନ ପିଟିସନଟା ବୋଧେ। ନାଇଁ ଏଇଟା ଇଏ କପିଟା।
Paragraph 7, 10th line from bottom.
ଏଠି ଇଲେକ୍ସନ ପିଟିସନରଙ୍କର କହିବା କଥା
ଆପଣ ଦୟାକରି ଛାଡି ଦିଅନ୍ତୁ, ସେ ଗଣିବେ। Let him allow to see you, please. Let him read and reply.
ସାରଙ୍କର କ୍ୱେଶ୍ଚିନ୍ ଶୁଣନ୍ତୁ,
ପାଇଲେ
ତାଙ୍କ ଆଭରମେଣ୍ଟ ଦେଖନ୍ତୁ। ଆପଣଙ୍କ
ଏଥିରେ ଇଲେକ୍ସନ ପିଟିସନରଙ୍କର ପ୍ଲିଡିଂ ହଉଛି it was incumbent upon the arrow to reject the nomination paper of the respondent, but the arrow illegally and improperly accepted the nomination paper filed by respondent in contravention of section 33 of the RP Act 1951, read with rule 4 of the conduct of election rules 1961.
It is not a fact.
Acha. The averments taken in the election petition in paragraph number, paragraph ta sir kete koidon?
Paragraph 7, 10th
7
line from bottom, 7A.
7 hyphen A.
ଆଜ୍ଞା
ଥିଲେ ଏଠି ମୁଁ ଦେଖିଲେ
page 7 paragraph 7
ସାର୍ ଟିକେ ରୁହ।
At page 8, 7A ପରେ କରନ୍ତୁ ନାହିଁ। At page 8 ପରେ 10th line from bottom. ସେଇଥିରେ ଅଛି।
ବୁଝିଲି।
it has been averred
The returning petition, returning officer should have rejected. ଏଇଟା ତ?
ଆଜ୍ଞା it was incumbent upon the returning officer.
କୋଉଟା ଆପଣ ପଚାରୁଛନ୍ତି ସାର୍ କୁହନ୍ତୁ? ମୁଁ ସେଇଠି it was incumbent to reject the assam. The averments taken in paragraph 7A bracket A ହେଲା?
At page 8.
As page 8.
10th line from bottom.
10th line from the bottom.
To the effect.
To the effect.
Comma, inverted comma begins.
Page 8.
Page 7.
ଏଇଟା ପେଜ କେତେ ଅଛି? 7 ନା 8? ଉପରେ ଦେଖ 7 8 ନୁହେଁ।
It was incumbent upon the arrow
ବାଡେଇ ଯାହା ଅଛି ପୁରା exactly
to reject the nomination paper returning officer.
It was incumbent upon the arrow to reject the returning officer କରନ୍ତୁ ପୁରା।
To reject the nomination paper of the respondent, but the arrow for the returning officer illegally and improperly accepted the nomination paper filed by respondent in contravention of section 33 of the RP Act 1951, comma, read with rule 4 of conduct of election rules 1961. ହେଲା
ଏତିକି ତ ସାର୍?
ନାଇଁ ଟିକେ
କଣ୍ଟିନ୍ୟୁ କର।
And further pleaded The RO should have rejected the nomination paper of respondent while
এটা এটি গোটে কাম করନ୍ତୁ and এই ଯୋଉ 1961 ପାଖରେ ଗୋଟେ କମା ଦିଏ ଏଇ ଯୋଉ end କରିଦିଅନ୍ତୁ ସେଟା inverted comma ଭିତରେ and further pleading କରିଦିଅନ୍ତୁ and further pleading that ପୁଣି again ଆଉ ଗୋଟେ ଆରମ୍ଭ
ଆଜ୍ଞା
pleading that କରନ୍ତୁ
the
again another ଆରମ୍ଭ
comma inverted comma begins
the returning officer
should have rejected the nomination of respondent
Recording stopped.
corner, comma inverted comma begins. The respondent had filed his nomination before RO returning officer on 2/4/2019, comma, along with his affidavit dated 3/4/2019, said to be in Form 26.
It is not a fact. It's not a fact. The averments taken in paragraph 7, এটা A তো?
7B, 7 capital B.
Page number টা কেতে ହେଲା?
Page
8.
এটা କେତେ number paragraph? আচ্ছা ହଁ ଚଳିବ first sub paragraph. First sub paragraph in the election petition to the effect that the respondent had filed his nomination before the returning officer on 2/4/2019 along with the affidavit dated 3/4/2019 said to be in Form 26 inverted comma ends are not correct. Stop.
After page 9,
Question. Sir.
5th line from top. The affidavit of respondent, the affidavit of respondent along with his nomination paper filed on 2/4/2019 is of dated 3/4/2019, which is a date subsequent to filing of nomination paper, comma, thus the affidavit dated 3/4/2019, comma, filed along with the nomination dated 2/4/2019 is no affidavit in the eye of law.
Yeah. So start the affidavit.
ଆଜ୍ଞା
ହଁ ଠିକ ଅଛି ଏଇଟା କଣ କହୁଛନ୍ତି not correct. The averments taken in paragraph 7B ତ sir
ଆଜ୍ଞା
7B at page এটা ହଉଛି କେତେ number
Page 9.
Huh?
Page 9.
page 9,
9. Fifth line from the top.
5th line from top.
In the election petition to the effect that এটা পাড়িয়ান the affidavit along with উল্লেখন the affidavit along with his nomination paper his bracket along with his আগে ওয়ার্ডটা দিয়েন along with his bracket করে দিন respondent ହେଲା nomination paper filed on 2/4/2019 is of dated 3/4/2019, which is a date subsequent to the filing of the nomination paper,
comma,
the
thus the
thus the affidavit dated 3/4/2019 filed along with the nomination dated 2/4/2019 2404 is no affidavit in the eye of law.
ସେଇଥିରେ ଟିକେ ମଝିରେ ରହିବ ଛଡା the affidavit dated 3/4/2019, filed on 2/4/2019 is in contravention of the mandate of law.
And inverted कर दें. And the affidavit dated 3/4/2019 filed on 2/4/2019 is in contravention of the mandate of the law. Inverted comma ends. ଆଉ କିଛି ପଚାରିବେ ସାର୍?
ଆଉ ଗୋଟେ ଅଛି
କୁହନ୍ତୁ।
ତାପରେ ହେଲା the arrow should have rejected the nomination,
ଠିକ ଅଛି।
the returning officer
नहीं हाँ से कमाटा ये जो ये काट दिया जो हाँ सेटा काट दिया and the returning officer should have
rejected the nomination papers
the nomination papers
filed by respondent on 2/4/2019
along with
affidavit dated 3/4/2019, but the same has not been done by the returning officer at the behest of respondent. Stop.
Sir, आउर गोटे लाइन अछि पर ता कंटिन्यू
and the returning officer has deliberately and illegally accepted the nomination paper.
Deliberately and illegally.
Again. Dated 2/4/2019, along with the affidavit dated 3/4/2019 of respondent.
ରହିଛି ଆହୁରି ଅଛି ସାର୍ ତାଙ୍କ ନାଁରେ ସବୁ ଅଛି।
Though it was the duty of the returning officer to reject the nomination paper of respondent
as the respondent has filed the affidavit, which is no affidavit as required under law. Back inverted comma ends are law, inverted comma ends are not correct. Sir, how could we allow?
No, how could
नहीं जरा दरकार नहीं रिपीटेशन
of the same ରହିଚन ना paragraph सेवन आई जे तो रिपीटेशन कर सेम ए जिंस टाइम
नहीं दरकार नहीं
नहीं शुड
sorry
okay.
Are not correct. ये तो सजेशन तो बोला वो सही बात है so
नहीं
properly
ठीक है. So that's all. Yes, Mr. Agrawal, Mr. Kanungo. Yeah, please.
Just allowed to see exhibit 41, 42, and 43.
No, you want to put some questions?
No. We just want.
No, if you just want to see it.
Yes.
Please. Mr. ठीक है हेल्प करूँ.
84 सेट ଅଛି.
हाँ ठीक है. देखिए जाओ.
39, 40, 41, 42.
No, 41, 42. If 41, 43, 43,
31
and 43.
And 43.
No, Mr. Kanungo, you are at a liberty. Suppose you are re-examination no ଗୋଟେ purview ଅଛି. ଯଦି by chance କିଛି କଣ omit କରିଥିବେ, you can put it because the witness is here. There is no problem in that. ଯଦି ଭାବୁଛନ୍ତି କଣ, there is no problem in that.
Because exhaustively, I think everything has come.
43 ଆ ଭିତରେ part ରହୁଛି. 43 ଟା ଥିବ.
42 ଟା
No, 41 and 43.
41 and 42.
41 and 43.
43 ତ?
ମୁଁ ଦେଖି ଦଉଛି.
39
ସେ କ୍ଲୋଜର ମେମୋଟା ଦେଲେ. सिस्टमेटिक କରି ରଖିବ. इलेक्शन से आईए करिया काम सरीगला. इलेक्शन पिटिशन है तापर इलेक्शन पिटिशन जो टाइम दिया है स्टेटमेंट तापर आईए गुड़ा को गोटे सेपरेट बंच कर दिया है कारण बर्तमान ये तापर रहिबो एविडेंस जो दिया गला यांकर तापर बर्तमान जो सेमानकर जो रेस्पोंडेंट जो एफिडेविट दबो है एविडेंस एफिडेविट तापर जेरा सो सिस्टमेटिक आर्गुमेंट कहीं से टाइप को सिस्टमेटिक कर दो लिखे. So-and-so is present today. His cross-examination is resumed. So-and-so appearing. Cross-examination is closed. Witness is discharged. Witness is discharged. Witness to see what to witness. The witness is discharged. Learned counsel for the election petition filed the closure memo for today, which is taken on record. Put up this matter.
सर्टिफाइड कॉपी हमको दो.
हाँ सर बोलिए. Put up this matter. Sir, around 31 तारीख पर.
नहीं 4 तारीख.
नहीं अपन
31 एक मना करथले बता.
अच्छा माने
31 एक रखिबेन.
हां एविडेंस एफिडेविट फाइल हो प्लस चीफ एग्जामिनेशन अपन जदी कोन करिया उछा. 4 तारीख माने शुक्रवार.
हां शुक्रवार.
टुडे है जाय. टुडे इज 20th.
हां सो नहीं आपनकर जेतिक डॉक्यूमेंट एग्जिबिट मार्क हेची दे विल दे तांकर दरकार अछि. आपण जदी दरकार चाहिबे ताले मु गोटे जनरल ऑर्डर कर दोची. हां कारण बहु डॉक्यूमेंट से मार्क करछंती जोडा आपण पाखरे नथिबो बा ता एग्जिबिट कोन हेची आपण न नेले असुविधा हो. So better होची you take the exhibits and let them come with the जो that evidence affidavit of respondent and the respondent will remain present on that day on 4th for his chief examination and other. So लिखि दियंतु.
ସେଥିରେ ଖାଲି ମୁଁ ସେଟା मेंशन କରିବା ଦରକାର ନାହିଁ. ମୁଁ ଶୁଣୁଛି କଣ ତାଙ୍କର ଆସେମ୍ବଲି ସେସନ 7-8 ବେଳକୁ ହେଇପାରେ. ଯଦି ହୁଏ ସେତେବେଳକୁ ସେ ତାଙ୍କର ଆପଣଙ୍କର ଲିଭ୍ ନେବେ. କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଚାଲିଥିବ ନା. ଚିଫ୍ ନେଇକି ଯୋଉ ଦିନ ରହିବ ସେଦିନ
ଆଗେ ଚିଫ୍ ଟା ମାନେ ଆରମ୍ଭ
ଚିଫ୍ ଟା ହେଇଯିବ. ଚିଫ୍ ହେବା ପାଇଁ କିଛି ଅସୁବିଧା ନାହିଁ.
It can be also end of this month if
the put up this matter on so and so. The matter is taken up on so and so day. Put up the matter will be no semiti lokon. The land and council kon. नहीं सीटा ताप पर लगन. Put up this matter on so and day. ताप पर लगन.
Yes sir.
Land council for the respondent submits that he will file the evidence affidavit of the respondent on that day, and the respondent and ensure the attendance of the respondent on that day for his examination in chief. Stop. ସେଇଦିନ ଫାଇଲ କଲେ କପି ଆପଣ ଦେବେ ତାଙ୍କୁ ଆଉ
ଆଜ୍ଞା
ହଁ ସାର୍ଟିଫାଇଡ କପିଜ କାହାର ନେବେ ନା ସେ ଜେନେରାଲ ଗୋଟେ ଲେଖିଦେବି ଆଚ୍ଛା ସାର୍ଟିଫାଇଡ କପି ଅଫ ଦି ଡକୁମେଣ୍ଟସ be supplied certified copy of the exhibited document certified copy of the exhibited documents be supplied to the
to both parties
the party if applied for on proper application be supplied to the land and council for both the parties
ସେ ଡେଟଟା ଦିଅ
ବାଇ ଆପଣ କେବେ ଆପ୍ଲାଏ କରିବେ ତାପରେ ମୁଁ ଗୋଟେ ଲାଇନ ଲେଖିଦେବି be supplied by 27th କରିଦଉଛି ଆପଣ ସୋମବାର ଆପ୍ଲାଏ କରିବେ ମାନେ 24 ତାରିଖ ଆପ୍ଲାଏ କରିବେ ହଁ ସେମାନେ 26 ତାରିଖ ଦିନ ତ ଛୁଟି ଅଛି 25 27 ଭିତରେ ଇଏ କରିକିନା ଆପଣ ଦେବେ ଆଉ କଣ ତ ଲାଟେଷ୍ଟ ବାଇ 28
ଶୀଘ୍ର ଦେଇପାରିବେ
ଭଲ ମନେ ହେଇଗଲାଣି
28 ତାରିଖ ଆଚ୍ଛା ବାଇ 31st ଦେଇଦେବେ କହିଲେ ଲେଖିଦଉଛି ଆଉ କଣ by 31st of August 31st of July 2023 the land and council for both the parties shall apply for the same if applied on or before by so and so be supplied to the land and council for both the party by so and so बस ठीक ଅଛି अब
सर ଏଇଠି ଟିକେ ରୁହନ୍ତୁ
ହଁ ଆଉ ଥରେ ସାର୍ ପଢେଇ ଦିଅନ୍ତୁ
ନାଇଁ 31 ତାରିଖ ଭିତରେ ଯଦି ଆମେ ସାର୍ଟିଫାଇଡ କପି ପାଇବୁ ତାପରେ ଆମକୁ ନିହାତି ସେ ଗୋଟାଏ ସପ୍ତାହ ଦିଅନ୍ତୁ
ସାର୍ ସେମିତି ଆଉ ଚାଲିଥିବ ତ
ତାହେଲେ ମୁଁ କହିଦଉଛି ସିଏ ଆମକୁ 27 ତାରିଖ ଭିତରେ ଆପଣ ଦେଇଦେବେ ଦ୍ୟାଟ ଇଜ ଦେୟାର ରେସ୍ପନ୍ସିବିଲିଟି ରେଜିଷ୍ଟର ରେସ୍ପନ୍ସିବିଲିଟି କଣ 27 କରନ୍ତୁ 27
ଦେଲେ ଆମେ
ହଁ 27 ଆଉ ଥରେ ଇଏଟା ପଢି ଦିଅନ୍ତୁ PW3 is present in court today. His cross-examination is resumed. Mr. Vidyadhar Misal and Sinan is appearing for the respondent, cross-examining. The cross-examination is closed. Witness is discharged. Land counsel for the election petition filed a closure memo in court today, which is taken on record. Put up this matter on sworn, so the matter will be taken up soon. Land counsel for the respondent submit that he will file the evidence affidavit of the respondent on that day, giving copy to the land and council, giving copy to the land and council, giving advance copy to them, giving advance copy to them, giving in advance, and ensure the attendance of the respondent on that day for his examination in chief. The certified copy.
On that day, that is
on that day bracket लिख दो 4 that is 4th April August 2023 for his exam the certified copy of the exhibited documents if applied for on proper application by 24th July 2023 be supplied to the land and council for both the parties latest by latest by 27 July 2023 documents kept in sealed cover are opened and the same be resealed and kept
ଘରେ ରହିଗଲେ ସେ ଆମକୁ ସାର୍ଟିଫାଇଡ କପି
ଆଚ୍ଛା କାଢି ଦିଅନ୍ତୁ ଓକେ
ନାଇଁ 4 ତାରିଖରେ ଯୋଉ ରହିବ
ଖାଲି ମାଇଲଟ କରିଦିଅନ୍ତି ଡକୁମେଣ୍ଟସ may be kept with registered judicial
ଖାଲି କରିଦିଅନ୍ତୁ the documents be kept with the land and register judicial ଏଠି ତ ଖାଲି କରନ୍ତୁ ପ୍ରପର କଷ୍ଟଡି ଦରକାର ନାହିଁ
4 ତାରିଖରେ ଯୋଉ ରହିବ
କୋଉଟା ସେଟା ତମେ କହିବ ତାଙ୍କୁ
ତାଙ୍କୁ ବୋଧେ ସଜେଇବା ପାଇଲେ ମୁଁ କାଢୁଛି
କହିବ ତାଙ୍କୁ
4 ତାରିଖରେ ଆମର ଯୋଉ ରହିବ ସେଇଟା 2ଟା ବେଳେ ରହିବ
ସାର୍ କହିଯିବ 2 ତାରିଖ 2ଟା ବେଳେ 4 ତାରିଖ ଶୁକ୍ରବାର memo accepted
I have filed them.
ঠিক আছে